Item number 41 from supplementary.
For reasons mentioned in the order, the prayer for bail of the petitioner is rejected at this time.
Oblige, your lordship. May it please, your lordship. Lordship, I have to mention for listing for withdrawal, lordship, today, lordship. Charge sheet has already been submitted, lordship.
Okay.
Oblige.
Also, item number 47, this was the matter regarding the modification of the bail condition. Also, fix the matter today, also. May I feel maybe taken up at 12 p.m. 12 noon, also.
Why?
12.
Why?
So, I have some personal agency in the second half.
Okay. Okay.
At 12 watch.
Okay.
Oblige.
Matter will be listed tomorrow, lawsuit. Not
Tomorrow, what matter?
so anticipatory. That matter, lawsuit is given a series of anticipatory bail, that hospital matter, all doctors.
When have you filed?
Today morning. I have already filed it this
Monday. There is no,
No, only problem, lawsuit, that day lawsuit was given 6 people of the hospital. He has no, now he has been brought to the police station. He has said, go to the toilet, clean the toilet, all these things he is doing, lawsuit.
okay, tomorrow.
That's my problem, otherwise not.
Tomorrow.
May lordship, with regard to item number 12, lordship, charge sheet has been filed, lordship. Item number 12.
So you go to the trial court,
Lordship, that observation, lord.
charge sheet number is there. Heard, you are withdrawing
Lordship, not withdrawing.
this,
lordship.
okay. Heard Mr. P. Bordole, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that charge sheet has already been delayed in this case. Stop. In view of submissions made by learned counsel for the petitioner, this bail application is disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Oblige, your lordship.
May I please, your lordship? I beg to mention item number 23 and 34. This matter kindly pass off for the day. The counsel for the petitioner is out of station.
23 and
Cancel it.
Miss, what is your name?
Jai Rajkumari.
J. Rajkumari, learned counsel appearing on behalf of Mr. P. Jeswekar, learned senior counsel for the in 23 for applicant Hobo, in 34 for petitioner, who prays for an adjournment on the ground that the conducting counsel is out of station. The prayer is allowed. Let this case be listed in the next week on a date to be fixed by registry.
May I please, your lordship? I beg to mention item number 46. Temporary has not been received, madam. We are an interim.
46, is there? Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed on 29th of August. The interim order shall continue till next day.
Oblige, madam. May I please, your lordship?
Yes.
Item number 32, lordship, and criminal appeal, lordship, for hearing. And earlier, lordship, and the third time was listed but not reached, lordship. And can it be taken to lordship?
No,
Very
no.
old pending case, 2011. lordship.
No. You have to wait for your turn. Bail matters are more urgent.
At
You
three-
wait,
At 3, lordship, and earlier 3 times our preparation was there, lordship.
wait for your turn and your
Lordship,
luck.
lordship. Oblige, lordship.
May I please the lordship? Lordship, this is an anticipatory valuation for listing of tomorrow, my lord.
When have you filed?
It was filed Monday, my lord. Number has already been.
Monday?
Yes, my lord.
Okay.
Oblige, my lord.
May it please, your lordship, with regard to item number 16, I have instruction to appear for the respondent number to inform it
I'll file my Vakalanama as well as an affidavit during the court hours. Can it be on Monday so that both the Vakalanama and
Who is for the?
I'm for
petition?
the petitioner.
You don't have any
Once,
objection.
if Lordship fixes it on Monday, my lord.
On request of learned counsel appearing for both the sides, let this matter be listed on 11th.
deeply
And
obliged.
Obliged.
May I please, Lord, so I wish to mention item number 19, my lord. In this matter, my lord, file for record was called for.
NCR is not received.
Not received. Item number
19, my lord.
heard Mr.
A Basumatari, my lord.
A. Mushahari, learned
No, my
counsel,
lord, A Basumatari.
sorry,
A
A.
Basumatari.
Basumatari, learned counsel for the petitioner. Also heard Miss
Yes, Chakravarti, DR.
P.S. Chakravarti, learned counsel for DRI. It appears from records that the scanned copy of the trial court records have not yet been received. Issue reminder for the same. Let this case be listed on 22nd of August.
Obliged, my lord.
Wait, please, Lordship.
Yes.
Number 37 below. Yeah. We are payable, sign for the petitioner, my lord. And payable to which 2 lakhs. That's number 2 million. Already I have paid million, to which 2 lakhs. My lord. I think my lord, he has no grievance, further grievance.
Your Honor, already we have received.
Who is for the petitioner?
Sign for the petitioner.
What is the matter?
Can I have million?
You wait for your turn. You want to withdraw?
Last quarter.
Yes,
What is your name?
A Malik. I am appearing on behalf of F.A. Laskar.
You cannot withdraw, you are respondent.
We have already received the
You-
money.
As per the last court order, my lord, 22 to 35.
Then you withdraw it. You are the petitioner.
I'm the petitioner, my lord. Matter will be closed, and that order will be set aside, and the matter will be closed.
No, we have to peruse the records. Wait for your turn.
For listing a bail application, Your Lordship was last listed on 1st of August, Your Lordship, but it was not reached, Your Lordship.
What is the matter? NDPS.
NDPS.
It had
Monday.
Monday. Failed.
Tuesday, obliged, Your Lordship.
You give the mention memo.
I think 42 for withdrawal.
Lordship, matter may be allowed for the withdrawal.
What is your name?
Oh, Ullah, on behalf of M.A. Chamla.
What is your submission? You,
Party instructed to not put the matter.
okay. You want to withdraw it?
Yes.
Heard, Mr.
Oh, Ullah, on behalf of M.A.
Item number 40.
40.
Oh, heard Mr. Ola submitting on behalf of Mr. M.H. Ahmed, who prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Daily list, Mosambia, I think one.
May please, Your Lordship. Lordship, this is a 483 bail application, but this is my second bail application, and the petitioner is behind the bars. Now, Your Lordship, for more than 3 years, 4 months and 25 days. I was arrested on 14/3/2022.
Why when your first bail was rejected?
My first bail was rejected on 28/12, 02/09/2024. That is with Lordship, page 80 to 86.
What is your ground? Yes, Miss.
Lordship, in this second bail application, we have mentioned here that 50 and 50A of the sections are not complied, your lordship here.
What else?
And then your lordship, where there are 15 witnesses, and out of 15 witnesses, only 2 witnesses have been examined so far, your lordship.
Yes,
Maybe LCR call lordship.
you'll be objecting. You will, are you objecting to the bail? Will you file any written objection?
And here, your lordship, out of the 8 accused, 3 accused have already been granted bail, your lordship.
We'll call for a status report and let them file objection. Heard Miss
M. Zomanpui.
M. Zomanpui, learned counsel for the petitioner. Also heard Miss N. Kotoki. N. Kakoti or Kotoki? N. Kakoti. N. Kakoti, learned counsel for NCB. Since this is for the second time the petitioner has approached this court seeking bail, let the status of the trial, let the scan copy of the trial court records be called for. Learned counsel for NCB also prays for some time for filing written objection. The prayer is allowed. Let this case be listed on 22-8.
May I please, your lordship? So this is second bail application, lordship. We last rejected on lordship 24th of July 2025,
Mm.
lordship. And today is 53 days, lordship. This is lordship CIDPS case number 4 of 2025. Case number 53 is the last rejected.
Is there is with you?
Case that perhaps taken, we don't know, we have taken stuff. Not today. Maybe fix a short date, we'll be, CID,
What was the matter here?
that,
Take
workshop
Yes.
employee, that.
the Water Resource Department. Then case diary may be with us. We will fix a short date on Monday. Mr. A. Ahmed, learned counsel for the petitioner. Also Mr. K.K. Parashar, learned additional public prosecutor, who submits that the case diary may be lying with the office of the additional public prosecutor, as same was recently called in connection with a bail application of the co-accused. Considering the submissions made by learned counsel, learned additional public prosecutor, let this case be listed on 12th Tuesday. Monday, we have too many cases. On 12th August for case diary.
Hello.
Item 3. May I please, your lordship? Lordship, item 3 and 4 may be taken up together, arising out of same cases.
Yes.
Pending investigation, lordship. From arising out of Disney PS case, lordship. Case diary will be.
Case diary would be required.
Required.
Heard Mr. B. Medhi, learned. Sorry, heard Mr. D. Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary. Let this matter be listed on
19.
20. Both cases same order,
Deeply obliged.
20 August.
Item 5. Lordship, in is a 302 case, lordship. In this case, lordship, except this petitioner, lordship, all the accused person already been on bail, lordship. Tax sheeted matter, lordship.
Sheeted matter.
Lordship. And on supplementary charge sheet was being filed against me.
Why trial court has rejected your bail?
Because there is a tribal session court, that's why Lordship, and it has not been committed till yes.
And who granted bail to the other accused persons?
By this honorable court as well as the learned JMFC also Lordship.
JMFC has, how much punishment is prescribed?
Life imprisonment is there, Lordship, but on the grounds of arrest, Lordship, the JMFC has granted bail.
Now, what is your submission?
So it was already
But the ground of arrest regarding this petition, Amalat is not annexed in the petition.
no, in this case, I'm not going to refer the grounds of arrest.
On what ground you are seeking bail?
Lordship, all charge sheet has been filed, Lordship, and all the accused are only done and last on bail.
That may not be a ground for granting you bail. You must have your own reasons.
Lordship, and case has not been committed till today, so it will take time for the Lordship.
In that case, Amalat, the scan copy may be called for at this.
No, if other accused. What is the accusation?
In case number 12, FIR, Lordship,
Who are you? What is your name?
Rafiqul Islam.
Rafiqul. You kidnapped the girl and her dead body,
As per the FIR, Lordship.
the case diary would be required and copy of the case. Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Let the scanned copy of the case diary of Baralum PS case number 188/2024 be called for from the trial court, from the committal court. Registry to take steps for requisitioning the scanned copy. Place this matter on 28.
Lordship, on correction, Lordship, as Hussein, Lordship, not as.
As Hussein.
From supplementary list.
Yes, Your Lordship, my lord, this is an application under Article 226(2) of the Constitution of India, my lord. Against territorial jurisdiction, my lord. Here I am reading it, the provision, my lord. Article 226(2), the power conferred by clause 1 to issue direction
No, no.
orders.
Why you are before this?
The petitioner has availed vehicle loan from a finance company, that is the respondent company, my lord, from the branch at Karimganj, my lord, and all the formalities were completed in Karimganj. The petitioner received the amount from Karimganj. He made all the repayment also there, my lord. But the respondent authority suddenly filed a complaint case in the court of the learned CJM Calcutta, my lord, which has no jurisdiction here because the place of cause of action is Karimganj in Assam, my lord.
Now you have it.
So has no jurisdiction, Amalat. How, Amalat?
Yes. You have approached this court with a plea that the court which issued summons or warrant,
Yes,
summons to you,
summons and subsequently warrant.
warrant to you has no jurisdiction. Now to decide this question, the jurisdiction is of Calcutta High Court.
Calcutta High Court has no, but Calcutta CJM court has no jurisdiction.
Who will decide that?
Decide because
No,
it is applicable before this honorable court because
No.
the place of cause of action is Assam, my lord, Karimganj.
cause of action for that complaint is Assam. But
Yes, my
we are not deciding the complaint, we are deciding the writ petition.
But it will be decided in Karimganj, my lord, if it is, my lord, if that is why I have made a prayer.
What
for
is the
setting
cause of
aside.
action for this writ petition? Cause of action is passing of an order by court at Kolkata. And that,
The cause of action is the regarding the, my lord, complaint, my lord,
That is first cause of action.
regarding the complaint, my lord. The
No.
complaint,
But-
yes, my lord, your lordship may kindly peruse.
no, I have
Yes, my
understood.
lord.
Yesterday also we had similar,
Yes, my lord, the cause of action.
the proper court before which you should challenge the impugn order is court at Kolkata.
But my lord, all the transactions were done in Assam, in the
We are
district of
not
Karimganj.
deciding that transaction.
That is
We,
why
we, no,
Article 226(2), my lord.
what we will be deciding?
My lord, because the learned court, CJM court, Calcutta has no jurisdiction to decide a case where the cause of action was in Assam.
That is what
Karimganj
my
district.
query is. Whether a judicial magistrate court at Kolkata has passed order rightly or wrongly, which is the proper court to
The
decide?
competent court is at Karimganj, my lord.
You are not understanding. You wait for a moment and listen to me carefully. You have impugned an order of a court at Kolkata. In this writ petition, you have impugned the order of court at Kolkata. That my query to you is, which is the court which should decide whether the court at Kolkata has gone beyond jurisdiction or within within jurisdiction, whether it is.
Has the power, my lord.
So why
That is why at this stage I am praying for issuing notice, my lord.
no?
After receiving notice.
First party
respondent
is state
will
of West
answer, my
Bengal,
lord.
how this could will itself is state
Notice
of
may
West Bengal.
go, my lord.
And
After receiving the notice, the matter may be decided.
This writ petition is not maintainable
Not-
unless you convince me.
Because as per the, my lord, it is very clear, my lord, in Article 226(2), my lord. The cause of action, initial cause of action, it is the question of the initial original cause of action. Here, my lord, all the, my lord, the formalities have been completed here. The petitioner received the amount from Karimganj branch. And my lord, he made the payment also, my lord. All the formalities have been completed. Your lordship may kindly see annexation A, B, and C, my lord.
Which order you are impugning?
My lord, the summons and the summons, my lord. We have received summons and only then we came to know that a case has been filed at page 22, my lord.
What relief you are seeking?
At present, my lord, I am seeking to set aside because it has
Set aside which order?
set aside the, my lord, some order of summons. my
Which is the proper court to do that? This is,
that should be filed,
Hmm.
that should be filed.
That should
by
have been filed
the
before the court of
Karimganj
Karimganj
zone, now
by the branch of the, my lord,
Yes.
finance company,
to decide
from
this.
where, my lord, the loan has been availed, my lord. But they have filed there, my lord. Nothing to do with it because the branch is in Karimganj and the head office is Chennai, not Kolkata, my lord.
this is not the proper court. You come up with some authority, otherwise I will dismiss it.
Then on Monday, your lordship may fix it. I'll place some judgments, my lord,
Okay,
in my.
heard Miss S.B. Chaudhary, done at counsel for the petition. Petitioner. A question of maintainability was raised by the court, to which the petitioner submits that she may be granted some time to produce some authority in support of her contention that the writ petition is maintainable.
My lord, I have one judgment, my lord. A relevant portion is my lord, similar to my case, my lord.
Yes.
This is the judgment, my lord. Relevant portion, page 722, my lord.
Sarah?
My lord, at page 722, now para is not given, my lord. I am reading from, my lord, at the middle, my lord. We are surprised not a little that a High Court of Calcutta should have exercised jurisdiction in a case where it had absolutely no jurisdiction. In that case, the contract is in question was executed at Aligarh. The construction work was to be carried out at Aligarh, and the contracts provided that in the event of dispute, the Aligarh court alone will have jurisdiction.
No,
The-
what was the matter in this case?
So here, my lord, the my lord, cause of action, place of cause of action was Aligarh, my lord. And the petition was filed in, complaint case was filed in Calcutta, my lord. So, my lord, the honorable court has interfered, my lord, that Calcutta court has no jurisdiction, my lord.
Do you want me to dismiss this or you want me
I'll
to?
place some other, I've
Oh,
got other judgments. also.
Okay. Oh, click on last line. The contention regarding maintainability of this writ petition. The prayer is allowed. Let this matter be listed
On Monday, my lord.
Tuesday. On
My
prayer.
lord, till then, at least interim protection, because the police is after him. Police
I am
is
questioning the maintainability and you are seeking relief. My understanding is that this is not maintainable. If I were to dictate an order, I will dismiss this on the question of maintainability. Still, you are given time.
Can we see the last order? A query was put.
Yes. Here, Ramkishore Arora has clarified
Correct.
that the requirement of a communicating grounds of arrest in writing would be applicable only from the date of judgment of Pankaj Bansal. And that is the law declared by Apex Court. Before that, if prosecution can show
My lord,
that it was otherwise communicated, then you don't have that ground. On that ground, you will.
just, I'm reading my lord, the subsequent, I'll hand over it, my lord.
What is it? No, let him submit. What is your submission? You took.
For the judgment of Kanishk Sinha matter, there is a clear judgment that every order of the court that will be retrospective.
No, order of the court is normally retrospective.
Yes, ma'am.
Unless specifically
Yes, ma'am.
stated.
Yes, ma'am.
But Ramkishore Arora has clarified. When a clarification has come from Apex Court, can this court go against that?
Yeah, we are saying lot. Actually, Bihan Kumar and Provin Prukresto judgment cannot be effective prospective. They are saying. On that issue, Malak, the judgment of the Kanishk Sinha is clear.
Judgment of?
Judgment of Kanishk Sinha, I have given your lordship, Malak, earlier.
Kanishk Sinha.
Yes. That perspective.
What it says?
The lordship will find. Paragraph 3. Paragraph 3, my lord.
Para, be louder.
Yes, my lord.
Para,
Para 3, my lord.
be.
Yes, my lord. Para 3, my lord. My lord, before para 4, my lord.
On which paragraph you are relying? Read that.
My lord. Paragraph my lord, 3, my lord. Paragraph 3. Last paragraph. Last portion of 3, my lord. Retrospective and prospective. my lord.
No, that, regarding that, there is no dispute regarding that.
Moreover, my lord.
The law is that all judgments are retrospective in
Yes.
effect, unless specifically clarified that it would be effective prospectively. Now, Apex Court has clarified in one of its judgment, Ram Kishore Arora, that the judgment of Pankaj Bansal, which required that the grounds of arrest are to be communicated in writing, will be applicable prospectively. That is what amicus submitted on the last day. Now, what is your counter to that?
My lord.
On last day, query was posed to the additional PP that is there anything else? If he is able to show that, then you don't have a case.
Yes, my lord. In coordinate bench, my lord, that issue, my lord, was raised, my lord, that was negated by the coordinate bench. This is the order.
But suppose Apex Court clarifies something and coordinate bench
And
gives a,
Ramakrishna Arora is the judgment of the prior to the Kanish Singha, my lord.
no, whether coordinate bench has declined to,
Let your lordship will find.
what is the observation of the
Yeah,
coordinate bench?
Yes, my lord. Page number 7, my lord, paragraph 18, my lord. My lord, bill application, my lord, 1600/2025, my lord. Once
Yes, please read loudly.
Though in the case of Pankaj Bansal, the word henceforth was used, meaning thereby from the date of pronouncement of the judgment, the law laid down herein would be applicable, and on such count, the Honorable Supreme Court has refused to give the effect of the same retrospective in the case of Ram Krishna Arora, and on such count, the admission, submission of the Mr. Thakur was some force. Yet there is no such direction in the case of Ram Bihan Kumar regarding the retrospective effect of said decision. And that being so, in the view of proposition of law so laid down in the case of the Kanish Singha.
No, but Vihan Kumar is not the first case where it was stated that it should be in writing. The first case is Pankaj Bansal's case. Thereafter, Prabir Purkasa. And Vihan Kumar is last in the series. When the first case itself, Apex Court itself has clarified whether any a contrary clarification by any other court would be binding on this court.
But moreover, my lord, the petitioner behind the bar more than two years, my lord, and there are only 13 prosecution witnesses was examined out of 40, my lord. And last prosecution was examined, my lord, in the month of April, my lord. Till date, no prosecution was examined, has not been examined. This is the long.
Out of 14, how many have been,
13, only 13, 1-3.
only one is remaining,
No, my lord, out of 14, 40,
40.
40.
Okay, okay.
Out of 40, my lord. Only 13, 1-3 have been examined. That was, my lord, 9/4/2025. From the 9/4/2025.
What is the date of your arrest?
My my lord, 04/07/2023.
23.
Yes, my lord.
Or how long you are behind the bars
My
now?
lord, 2 years, 1 month, 3 days, my lord. And on long incarceration, I have some authority, my lord.
Yes, Mr. They,
Now, there is note of the IO method. As per the report method, now I arrested the above mentioned accused person as their prima facie evidence against them in connection with the case. They have been informed about the grounds of arrest and their rights as per section 50 KRPC as well as KRPC. The accused person are not cooperating and guilty. In the order also, Malak, order of magistrate Malak, there is a notice to IO Malak, he has communicated. The accused person has been duly informed of the grounds of arrest.
order dated?
That is 5/7. Note of the IO is 4/7/23.
Okay, regarding prolonged incarceration.
All such cases, this similar girl is around.
No.
14.
Whether victim girl has been examined.
This is.
Oh, she is
This is right.
Okay, this is not an NDPS case.
And on the note, he was arrested on 4/7. Note of the IO is at the time of arrest, they have been informed the grounds of arrest. And as per the right under section 50 of this. 5/7 order reflects the accused person has been duly informed of the grounds of arrest as managed under section. The family members of the accused person have been duly informed by the police as managed section 50A of the state.
But I have submission, my lord, on that point, my lord. If there is any other mood to communicate the ground of arrest to the accused petitioner, my lord, except the section 50, my lord, except the notice of under section 50, my lord. The notice says that no, no ground was mentioned, no ground was communicated, my lord. I have annexed, my lord, that notice, my lord, and here there I referred the order, my lord, and I have annexed that notice, my lord. Is there any mood?
Orally, you can be informed.
No, orally that can be done, but the but is the why the written was not informed, my lord? Why the arrest ground of arrest was not informed written, my lord? Since the notice was issued under 50, my lord. Why? What is the necessary to communicate orally, my lord? Since the
Okay.
notice is there, my lord.
Okay. Yes.
But that is the practice going on the time. And for that practice, he was thoroughly informed. And the IO itself on the same day, his note 4/7 is mentioned in the case diary that he has been informed about the and fourth, when he was produced on 5/7. What was stated that as per the informed by the IO. Family members also informed, he has been informed the council.
But I have submission on that point, my lord. The judgment of the Bihan Kumar and Probin POCSO has not been created any new one, my lord. That is the recitation and reaffirm the earlier, my lord, existing law, my lord. That is the article 22(1) and section 50, my lord. Nothing has been created. That is the recitation reaffirmed the law. So it is applicable from the date of enactment, my lord. That is my submission. So that nothing is new, my lord. By these two order, it clarified the ground of the arrest should be given to the accused person, and that is incorporated in the section 50 of CRPC, my lord, and article 2022(1), my lord.
Okay. Yes, you have anything? Whatever you have submitted. Okay. Heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Ms. M.K. Brown, learned amicus curiae for respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Rafiqul Islam, who has been detained behind the bars since 4/7/2023 within bracket for more than 2 years, 1 month bracket close in connection with what is the case number?
Dubri PS case number, my lord.
What is the
666.
special PSK? Special case number
Yes, my lord.
180/2020 corresponding to Dubri PS case number 266/2023 under section 365/376 DA/306 of Indian Penal Code, read with section 6 of the POCSO Act, 2012. The gist of accusation in this case, where is the FIR? That on 36/2023, the father of the victim girl had lodged an FIR before the officer in charge of Bazar Nagar Police Outpost under Dhubri Police Station, inter alia, alleging that his minor daughter, on 29/6/2023 at around 1 p.m, had accompanied 3 of her friends and went to visit Fulbari Bridge. It is alleged in the FIR that the accused persons named in the FIR, including the present petitioner,
In the FIR, no opposition.
offered lift to them on bike or dropping them in their respective homes. However, they took the victim to Aminej Chor and was raped by the petitioner and his accomplice. By the petitioner. Your name is Rafiqul.
Yes, my lord. As per FIR, my lord, no accusation against the petitioner, my lord.
By the Jahirul Islam. And on the same day, the daughter of the petitioner committed suicide. Stop. Learned counsel for the petitioner has submitted that the petitioner is seeking bail mainly on two counts. Namely, that no grounds of arrest were communicated to him when he was arrested in connection with this aforesaid case. Stop. And on the ground of prolonged incarceration. Stop. Learned counsel for the petitioner has submitted that though notice under 50 of the Code of Criminal Procedure 1973 was served on the petitioner at the time of his arrest. Where is the notice?
But the worship will find my additional affidavit, my lord. Page
However, said notice did not contain any ground of arrest. Neither it contained the basic facts which necessitated his arrest in connection with the aforesaid case. He submits that the notice only contained information regarding the police station case number as well as the penal provisions involved in the case. And hence he submits that there is violation of the fundamental rights of the petitioner guaranteed under Article 22 within bracket 1 of the Constitution of India. Stop. In support of his submission, learned counsel for the petitioner has cited ruling of the apex court in the case of which in the case of Prabir Purkayastha versus State within bracket NCT of Delhi reported in 2024 8 SCC 254 as well as Vihan Kumar versus State of Haryana reported in 2025 SCC online SC 269. Any other case you are relying?
Yes, my lord. There is a bill application, my lord, of High Court of Bombay, my lord. Long incarceration. I have, my lord.
Learned, give that to me.
I was
You have given. Learned counsel for the petitioner has also submitted that the petitioner is seeking bail also on the ground of prolonged incarceration. Stop. He submits that the petitioner has been languishing behind the bars for last more than 2 years, 1 month. However, till date, out of 40 listed prosecution witnesses, only 3 have been examined.
13,
And
madam.
only 13 have been examined. And considering the pace at which trial is progressing, it is unlikely that it would culminate soon. Stop. Where is that Bombay High Court?
Yes, my lord.
What is the citation?
My lord, citation.
That is a
Bill application,
citation.
bill application number 3284.
You give a copy of that.
Yes, I have given
Bail application number?
23248/2024.
No, you give a photocopy of that. It is not there.
I have given photocopy morning mail. Just now I have given. Just now. 2 copies I have given. I'll give you again, my lord.
Okay, okay,
Yes,
okay. Means he's he लिखले last. He also submits that the prolonged incarceration of the petitioner has infringed his fundamental rights guaranteed to him under Article 21 of the Constitution of India. And on that count, he is entitled to get bail. In support of his submission, learned counsel for the petitioner has cited a ruling of High Court of Bombay in the case of Digambar Uddhav Supekar versus State of Maharashtra, order dated 16 October 2024 in bail application number 3284/2024. Which para you are relying?
10, 11, 12, and 17.
Stop. On the other hand, learned additional public prosecutor has opposed vehemently the grant of bail to the petitioner on the ground that there are sufficient incriminating materials in the record against the present petitioner, and some of the material witnesses are yet to be examined. He also submits that the grounds of arrest were communicated to him at the time of his arrest as apparent from the endorsement made in the case diary to that effect by the investigating officer. He also submits that in order dated
5/7.
5/7/2023 passed by learned judicial magistrate, or
Maybe the MFC, but
the special judge. POCSO. Blank Rakiba. It is mentioned that the grounds of arrest were communicated to the petitioner at the time of
special judgment,
special judge
Dhubri,
Dubri,
special judge POCSO. Dhubri.
special judge POCSO Dubri. Last line can mention that. And the time after he was arrested, he submits that the clarification, the requirement of punishing written grounds of arrest is there only from the date of the judgment of the apex court in the case of Pankaj Bansal versus Union of India, reported in Union of India Supra, as has been clarified by the apex court in the case of Ram Kishore Arora versus Directorate of Enforcement within the Supra. Anything else from your side?
Well, it is. Well,
Who are yet to be examined?
doctor or is not examined.
Okay, stop.
Sir, they are including the doctor and the
Learned Miss M.K. Brown, learned amicus curiae, also submitted similar to that of learned additional public prosecutor, and has opposed the grant of bail to the petitioner at this stage. She submits that in the case of Ram Kishore Arora versus Directorate of Enforcement, the apex enforcement within bracket Supra, the apex court has clarified that the use of phrase within bracket hence within inverted comma henceforth in the judgment of Pankaj Bansal versus Union of India within bracket Supra by the apex court would mean that the requirement of one communicating the grounds of arrest, to an arrestee would be applicable prospectively from the date of the judgment of apex court in the case of Pankaj Bansal. She also submits that if there is material on records to indicate that the grounds of arrest were otherwise communicated to an arrestee in case where arrest has been made prior to the judgment of Pankaj Bansal, such communication may not be regarded as infringement of the fundamental rights of a person guaranteed under Article 22(1) of the Constitution of India. Stop. In response to the submissions made by learned counsel for learned additional public prosecutor as well as learned amicus curiae regarding non-requirement of furnishing written ground of arrest in writing in cases where such arrest was made prior to the judgment of Pankaj Bansal within bracket Supra. He has cited a ruling of the coordinate bench of this court in the case of Rafiqul Haq alias Mirazul Haq versus State of Assam within bracket order dated 2/6/2025 as well as 2/6/2025 in bail application number 1600/2025 as well as the judgment of the apex court in the case of Kanish Sinha and another versus State of West Bengal and another, reported in 2025 SCC Online SC 443, wherein it was observed that judicial decisions are normally retrospective in application unless mentioned otherwise therein. He also submits that in the case of the decisions of the apex court in the in Prabir Purkayastha within bracket Supra and Vihan Kumar within bracket Supra, there was no indication that the requirement of furnishing written grounds of arrest to an arrestee would be applicable prospectively. Stop. I have considered the submissions made by learned counsel. Case बिलागे एकेलगे रखो. Learned counsel for both sides and have gone through the rulings cited by them as well as the scanned copy of the records of scanned copy of the trial court records, which was requisitioned in connection with this case. Stop. Remaining, I will dictate in chamber. I have to apply some. Today itself, I'll deliver the judgment. Was not mentioned. Yes. Okay. I'll consider.
Obliged.
Item 7.
Lordship, Lordship, this matter may be fixed tomorrow, Lordship. My senior will appear.
Tomorrow.
Tomorrow, my lord, I have found, let it be on next week, my lord.
Tomorrow we have also difficulty.
Because my lord, only thing is that 48, my lord, whether it was served or not. Your lord, see record is available.
Let it be
48,
on Tuesday. They are seeking.
From the record, my lord, it is not available. I
It
check
is
it out.
not there on record, but I have the 47 notice, 48 notice, everything I have.
That is why okay, my lord, if your lord say adjourn the matter, I will not open to up today, my lord.
Heard Mr. N.N.B.
Next-
Chaudhary, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB, who's raised for a short adjournment on the ground that learned standing counsel NCB has some difficulty today, considering the submissions made by learned counsel for NCB. This case is adjourned for the day. Let it be listed on 12.
In listing my other matter, my lord, I want to say I have gone to the Ramlal, my lord, but fundamental right has come, my lord, 1950 in the Constitution, my lord. And my lord, there are enough judgment that procedural law is always, my lord, prospective, substantive, or retrospective. I have gone to the judgment passed by the Honorable Justice so, my lord. That part, my lord, he never said that fundamental right was not violated. Only said that this judgment is the prospective effect. Just now, but he has never said, she has never said in the judgment that fundamental right was not violated.
Where, which judgment?
You have to say Ramlal, Ramkrishna, my lord.
Oh.
Never say fundamental right not violated. Interesting judgment, my lord. I have gone to the last now, my lord.
Item 8.
And NSA cases, many NSA cases, the fundamental right. Because, my lord, Vihan Kumar and Purkayastha or Sit Singh Constitution bench judgment has been flow here, my lord. And if it is NSA, my lord, there is enough judgment, 5 judges judgment, 4 judges judgment, my lord. When ground of arrest was not applied, fundamental right has been violated.
Okay, I'll consider.
Okay.
Next item.
Item eight, Lordship, LCR not received. LCR nine.
Heard Mr. A. M. Khan, learned counsel for the petitioner. Also heard Ms. M. Deka, learned additional public prosecutor. This. The. On perusal of the office notice there,
Is there that Lordship, scan copy not received.
on perusal of the office note dated 5/8/2025, it appears that the scanned copy of the trial court record have not yet been received. Issue reminder for the same. Let this case be listed on 22nd August.
Item 9.
Twenty-one and 22.
Videos call for your honor, probably.
Is there?
Something was just now.
Okay. Let him go through.
Item 10. Wait, please, the Lordship. Lordship, the offense under section 20B of NDPS. For allegation of FI space 12. 6.7 kg the report from the.
How much?
6.7.
It is not available, Lordship.
But today is 50 or
One,
yes, Lordship.
6.7 kg.
Intermediate.
they made a prayer, Lordship. IO has made a prayer.
But
But today I am able to fit
the
it.
line session for the. Today is 50 is that 2 acres on city location. But you kindly considering that length of detention period. The petitioner may be released. The petitioner is the wife Lordship of the case number 1. And she has no knowledge about the alleged article. The police
Why
came to-
Kesari was not seen?
Lordship, they have made a prayer that the submit a prayer in the, but today I am unable to submit the case diary before the honorable. Kindly refix another date.
No, why he was unable?
It hasn't been there, Lordship.
They have to mention some ground.
My dear. Never.
Always delaying the dissolving the court order. That's 2 occasions, Lordship. 6.7 kg under the 50 days, Lordship. Mandatory 60 days.
Okay. Heard Mr. M.Z. Shah, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Otherwise, what is your objection
But this is
from bail
Lordship,
application?
because this is a intermediate quantity, Lordship.
Also heard Mr. K.K. Das, who submits that though the case diary was called for, however, the investigating officer could not send the case diary and has prayed for some more time for producing the case diary. On the other hand, learned counsel for the petitioner has submitted that the considering the period of detention undergone as well as quantity of contraband recovered in this case, he may be allowed to, the petitioner may be allowed to go on. So this application under section 483 of BNSS has been filed by the petitioner Monu Gaur, alias Monu Gaur, who has been detained behind the bars since 19/6/2025, within bracket, for last 51 days in connection with Fatahil Ambari PS case number 96/2025 under section 20B2C. Now 20B2B, 20 within bracket small b, within bracket small Roman 2, B/29 of the NDPS Act. The gist of accusation in this case is that on 19/6/2025, one Ruel Soikia, SI of police, had lodged an FIR before the officer in charge of Ambari police station, inter alia, alleging that on receipt of an information through reliable sources, regarding storage of suspected ganja in the house of Jiten Gaur, a search operation was conducted and the house of Jiten Gaur was searched. During search operation, .7 kgs of suspected ganja was recovered there. What happened to your husband?
Husband, I have no knowledge about the offense of my husband. I am a heart patient, but I was in the house
He was arrested on what?
same day.
He was also arrested.
Arrested. Same day, 19/6, and he has been released. by the
Learned counsel for the petitioner submits that the petitioner does not have any knowledge about storage of recovered ganja in their house. He submits that the husband of the petitioner, Jiten Gaur, was also arrested in connection with this case. Learned counsel for this petitioner also submits that the petitioner is a lady and has been detained behind the bars for last 51 days, and the suspected ganja has already been recovered. Hence, he submits that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor, apart from praying for another date for producing the case diary, has objected to grant of bail.
Because possession is from his possession.
Objected to grant of bail to the petitioner at this stage, as the suspected ganja was recovered from her possession. Stop. I have considered the submissions made by learned counsel for both sides. Though the investigating officer has communicated to the office of a public prosecutor seeking a further date for sending the case diary. However, no reasons have been cited as to why case diary could not be sent today. Stop. Moreover, considering the fact that the petitioner, who is a lady, has been detained behind the bars for last 51 days, as well as considering the quantity of contraband seized in this case, this court is of opinion that if she cooperates in investigation, the further custodial interrogation, detention of the petitioner may not be necessary for fair completion of the investigation of the aforesaid case. Stop. For aforesaid reasons, the petitioner, Srimati Monu Gaur, is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of London Special Judge Kamrup Metro. This bail application is accordingly disposed of.
Item 11.
May it please the matter. It's a charge sheeted case, my lord, where the petitioner was arrested on, my lord, 3/11/24, my lord. My lord, here, my lord, my ground is of twofold, my lord. First, my lord, the notice under section 47, although it was issued, my lord, nothing specific is there. And moreover, my lord, section 48(1) notice was not served upon the family members of the petitioner. If your lordship takes the LCR, my lord, page 37. Page 37, my lord. I have been told it is a flag mark, my lord. The lordship sees, my lord, page 37, which is a notice under section 47, my lord.
37 of the LCR.
LCR, my lord. Page 37 of the LCR.
Yes.
Here, your lordship, my lord. Number one, the suspected NDPS contraband, that is Yaba tablets, have been recovered and seized from your possession. Confession has been made by you of carrying the seized recorded suspected Yaba tablet. Only these two paragraphs, my lord.
That is enough.
My lord, whether it will suffice, my lord. My lord, I'm directly going to a judgment of the apex court, my lord.
Yes.
My lord, where it says, my lord. Last page, my lord, paragraph 36. This is the case, my lord, where the petitioner was arrested, my lord, the present petitioner was arrested, my lord, on the strength of a warrant. So now lordship may turn to page 33, below the pagination is given there, my lord, paragraph 36, my lord.
Yes.
It says, my lord, if a person is arrested on a warrant, the ground for reasons for the arrest is warrant itself. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed of the grounds of his arrest. Now, my lord, if he is arrested without a warrant, he must be told why he has been arrested. If he is arrested for committing an offense, he must be told that he has committed a certain offense for which he would be placed in trial. In order to inform him that he has committed a certain offense, he must be told of the act done by him which amounts to offense. He must be informed of the precise act done by him for which he would be tried. Informing him merely of the law applicable to such act would not be enough. Now, my lord, lordship will see, my lord, see Vimol Kishore Mehrotra, my lord. And this is a case, my lord, by the Allahabad High Court, my lord, division bench, my lord. It was settled, my lord, in the year 1956, my lord. It was reported, my lord, AIR 1956, Allahabad, page 56. So this should be there. But from the 47 notice, my lord, only two paragraphs, my lord. Suspected NDPS contraband, that is Yaba tablets, have been recovered from you. Confession has been made by you. Only two paragraphs, my lord. But from going through the judgment, my lord, it says, my lord, he should be informed that he had committed a certain offense for which he
Offense under 22C.
C, for which he would be placed on trial, my lord. In order to inform
No,
him that
that is also mentioned, you. So you are forwarded to court.
yes,
No, this 47 notice in my understanding is sufficient compliance. What was found in your possession,
that was there.
how
But-
much,
But he must be told of the acts done by him for which amounts to the offense, my lord.
that is the act.
And he must be informed of the precise act done by him for which he would be tried.
The precise act is possessing
Okay.
Java tablet.
But that I have placed, my lord, the lordship will see, my lord, that part, my lord. And second part, my lord, so far 48 is concerned, my lord, that has not been served, my lord. Only a W2 message has been, next page, my lord, page 38, my lord. One W2 message is there, my lord. And that was sent to the OC, my lord. Yes.
Yes.
Now, if your lordship takes, my lord, the BNSS, my lord, for a only 48 section I have to go, my lord. 48(1), my lord. My lord, so far 47 is concerned, my lord, it is same as 50 CRPC, my lord. And now, my lord, 48, my lord, and 50 capital A, my lord, same, my lord, but only one line has been added to this section, my lord. Lordship will see, my lord. Obligation of person making arrest to inform about arrest, etc., to relatives or friend. Every police officer or other person making any arrest under this Sanhita shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his relative, friends, or such other persons, or as may be disclosed or nominated by the arrested person for the purpose of giving such information. Well, up to this 50A is, my lord, same. Now this part has been added, my lord, in this new amendment, new book, my lord, and also to the designated police officer in the district, my lord. So the state government is required to, my lord, appoint a designated officer in every district, my lord. So because the present petitioner hails from Tripura, my lord, even if the family members got the information that he has been arrested, they will come down to Guwahati, my lord, from where they will come to know, my lord, under what section, under what provision he has been arrested. So the relatives or the friends shall approach that designated officer, my lord. Now, my lord,
Where it is provided that
designated officer, my lord.
this phrase designated officer was where it has been mentioned in
Section
Dekebasu,
Section 37
section 37.
of this act. What is designated officer? Who is a designated officer?
37 of BNSS.
Yes, my lord.
Read it.
My lord. Section 37, designated police officer. The state government shall establish a police control in every district at the state level. Designate a police officer in every district, in every police station, not below the rank of the assistant sub-inspector of police, who shall be responsible for maintaining the information about the name and address of the person arrested, nature of the offense, which is charged, which shall be prominently displayed in any manner, including in digital mode in every police station and at the district headquarters. So whether, my lord, the state of Assam, my lord, had appointed a designated officer, my lord.
Okay.
That will people will,
Assuming that it has not appointed,
yes.
then
Suppose the information is given to my family members. We hail from Tripura. Just the information, the Mr. X has been your husband.
no information from information he has to be given by the arresting authority.
Yes, my lord.
So somebody would be informing.
Yes. my lord. In the instant case, my lord, one WT message has been sent to the OC Sonamara PS. Request to inform his family members or relative accordingly. Page 38. my lord. So if the family members come down to Guwahati, my lord, where shall they go? They have to go to the designated officer. Why
They may come to the police station.
police
which-
station, but the law says it's from the designated officer.
Okay, then what is your submission?
My submission is filed that 48(1) has not been followed in this case. No notice has been served. The family members didn't receive any notice after 40.
Okay,
And this information also we didn't receive, madam, that he had been arrested. Till date, madam.
yes, Mr. Sharma, you find out.
Yes, we'll have to find out, Lordship. Otherwise, if Lordship takes up page 23, the Chassis Lordship,
Page
23.
23 of the record.
Bail application. yes.
Petition from here. Is Apollo?
23.
Yes,
Lordship will find Greftari Podokiak.
where are you reading?
The first line, Lordship, at page 23.
Page 24,
23.
23.
Yes.
Gosaror, yes, read.
Greftari Podokiak. পরীক্ষা
পরীক্ষা
WT মেসেজ আৰু
পৰকীয়াৰ আত্মীয়ক জনোৱাৰ বাবে স্থানীয় পুলিচ থানালৈ অনাতাঁৰ বাৰ্তা প্ৰেৰণ কৰা হয়।
and I have been informed, Lordship, that officer is present in every district.
Presently,
Present in district as envisaged in the section, Lordship.
the designated officer.
Yes, it is there, Lordship. But regarding, to be fair enough, Lordship, the scan copy contains the WT message that was sent.
Page 30.
In the scan copy, I have already flag marked, Lordship. That was sent on 4/11/24.
No, that was sent to police station only.
Yes,
From police station, whether it was sent,
it's that information, Lordship.
that is required. While sending WT message, you have to mention that please intimate back after serving the notice, because they have to report to the court
Yes.
that they have complied with 48 notice. Unless the issuing police officer, if
Yes.
the notice is issued to some other police station, is informed regarding service.
Yes,
It is only say, it remains now, the material available shows that it was sent to a police station.
yes,
From there, whether it was
yes.
served.
That, Lordship, is not in the scan copy, in the records, Lordship. And Lordship, when telephone call was also made, that is apparent from the, what I have read, Lordship. The telephone call was also made. স্থানীয় পুলিশ থানালৈ অনাতাঁৰ বাৰ্তা প্ৰেৰণ কৰা হয়। So that compliance, Lordship, then I will have to take instruction. In the
Take
red-
instructions.
Instruction to that effect, madam, whether any notice was served.
Yes. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. In this bail application, the petitioner is mainly seeking bail on the grounds that there has been violation of the constitutional mandate of Article 22(1) of the Constitution of India, inasmuch as notice issued to the notice which was served on the petitioner under section 47 of BNSS did not contain any ground of arrest as required under law. Stop. It is also submitted by learned counsel for the petitioner that there has also been violation of the requirement of section 48 of BNSS, inasmuch as no notice has been received by any family members, friends, or nominated person of the petitioner, wherein grounds of arrest were mentioned. Grounds of arrest of the petitioner have been stated. Stop. Learned additional public prosecutor, on the other hand, submits that the petitioner was served a notice under 47 of BNSS at the time of his arrest, and same consists of all the basic facts which necessitated his arrest in connection with the case in which he was arrested. Stop. Learned counsel for learned additional public prosecutor has also submitted that from the scanned copy of the records, it appears that a WT message was sent to the officer in charge of Sonamura police station for intimating the grounds of arrest to the family members of the present petitioner. He, however, fairly submits that though the record shows that the said WT message was sent on 4/11/2024, there is nothing on record which would indicate that whether the family members / friends / nominated person of the petitioner were in fact communicated the grounds of arrest, or whether the officer in charge of Sonamura police station had communicated the grounds of arrest to the family members / friends of the petitioner in writing. He therefore seeks some time to get instructions in this regard. The prayer is allowed. Let this case be listed when?
It will also direct.
21. Let this case be listed on. How much was the contraband?
Yaba tablet, my lord, 9,800 Yaba tablet
21.
with plastic bag.
So a copy of the order may be furnished to me.
Let a copy of order be furnished to learned additional public prosecutor.
Item 6/12, item 47.
IA for modification of a bail condition. On last occasion, this honorable court asked me with submission whether this honorable court can invoke inherent jurisdiction to modify the bail condition and also to find some judgment in this regard, Lordship. Okay, Lordship, I was granted bail, Lordship, on 28/5/2025. And one of my conditions of release is that that I had to furnish two COTs, and the COTs has to be from the district of Sribhumi. I am seeking modification of that bail condition also. Now, in this regard.
What modification you are seeking?
My-
District should be changed.
State of Assam. So
Okay.
I am from Guwahati, and I'm having that is a very difficult to find COT from Sribhumi.
Okay. Now regarding power,
Power. Here, Lordship, under CRPC and BNSS, there is no specific provision for with regard to the modification of the bail condition imposed upon by this honorable court. However, in 439 and of CRPC 1A, their conditions were imposed, and if the conditions were imposed by the magistrate, then this honorable can modify the bail condition. And
now 480.
yes, now 480, 483.
483.
Since there is no specific provision in the CRPC and BNSS, therefore the various high courts and Supreme Court has held that inherent jurisdiction can be invoked. Now there was also question raised for various high courts and also Supreme Court that whether the bar contained in section 362 of CRPC, now perimeter provision of 403 of BNSS, whether that will stand in the way from exercising the inherent jurisdiction. And it was held that the bar contained in 362 will not apply. I'll place judgments in that regard, Lordship. First, Lordship, I would like to place one judgment from Madhya Pradesh High Court. It is Jagdish Arora and others versus Union of India. This is a very important judgment. May I place it? Here the question was whether the High Court has the inherent power to modify or delete the conditions subject to which bail is granted under section 439(1) subclause A, clause A of CRPC through inherent powers under section 482 of CRPC to ensure the ends of justice. Here, one of the condition was imposed that the accused has to deposit his passport with the trial court. This was the condition that sought for modification. Here I am relying on Lordship para number 8.2 of the judgment. And here the objection was raised by the state that since there is a bar under section 362 of CRPC, therefore inherent jurisdiction cannot be invoked. Here the Honorable Madhya Pradesh High Court has held that in para 8.2 may I read?
Yes.
The power of amending or deleting any condition subject to his bail order under section 439(1)A of CRPC is granted is however not expressly provided in the CRPC. Thus, the only course available for seeking granting modification, deletion of such condition is by invoking the inherent powers of this court under section 482 of CRPC to ensure the ends of justice. Section 482 of CRPC saves the inherent powers of the court to be exercised inter alia to secure the ends of justice. The ends of justice can only be secured when it, in absence of any express provision in this code, is not prevented from deleting, modifying any of the conditions subject to which an order of bail under section 439(1)A of CRPC is passed. If such inherent powers are otherwise not available to this code under section 482 of CRPC, then object of insertion of section 482 of CRPC would stand defeated, and this code would be rendered as toothless tiger. And in view of this findings, Lordship, the bail condition was modified. Para 11 is the modified bail condition.
Okay, that is not.
And thereafter, relying on this judgment, the Allahabad High Court passed one judgment. Relying on this judgment, I would like to place the judgment also.
Okay, that is not required. Whether apex court.
In apex court, there was a judgment. Here, although there is no specific findings with regard to the power of the inherent jurisdiction of this honorable court, but in essence, this judgment supports my submission, contention.
Yes.
Here learned High Court, here Honorable High Court declined to modify the bail condition
in view of the bar contained in section 362 of CRPC. But Honorable Supreme Court has held that that bar is not applicable.
We read.
A very small judgment. I'm reading from para 3. The appeal is filed being aggrieved by the impugn order dated so and so passed by the High Court of Judicature of Patna in criminal miscellaneous number so and so in criminal miscellaneous number so and so, whereby the said High Court has refused to entertain the petition seeking modification of the condition number 3 imposed by the High Court by order dated so and so. It appears that the High Court refused to entertain the said petition pressing into service section 362 of CRPC, which has no application to the facts of the case, since the father of the appellant has already expired. As rightly submitted by the learned counsel for the appellant, it was not possible to comply with the condition number so and so, which required that one of the bailers should be father of the appellant. Under the circumstances, the condition number 3 is modified as under one of the bailers shall be the brother of the appellant. Here, the bar contained under section 362 that was negated. And in fact, many high courts passed judgment in the similar line, that in the Allahabad High Court judgment, it was reflected. Including Lordship, Bombay High Court and Gujarat High Court.
Yes, Mr. Sharma. Where is the bar now? From the corresponding provision of 362 is in BNS 403.
403.
Mr. B. Bora, learned counsel for the applicant. Also, Mr. B. Sharma, learned additional public prosecutor. This interlocutory application under section 528 of BNSS has been filed by the petitioner, namely Shri Rajesh Kumar, praying for modification of one of the condition imposed while imposed in order dated 28/5/2025, passed in bail application number 1464/2025 by this court. By the aforesaid order, the petitioner was allowed to go on bail on certain conditions. Learned counsel for the petitioner has submitted that the order dated 28/5/2025, while granting bail to the present petitioner, had imposed. Where is the condition?
Para number 16, page 13. Yes.
Has imposed condition number 1 that condition at para 16 of the said order that the petitioner is allowed to go on bail of rupees 2 lakhs with 2 local sureties, both of whom should be permanent resident of Shri Bhumi district. So, learned counsel for the petitioner has submitted that since the petitioner hails from Guwahati, hence arranging sureties from Sri Bhumi district has become onerous to him, as he does not have any known person in Sri Bhumi district who a known person in Sri Bhumi district, and no one is ready to become his surety from that district. However, learned counsel for the petitioner submits that the petitioner who will be able to arrange sureties from either Guwahati or any other part of within the state of Assam. Hence, he prays that the paid modification may be allowed for the ends of justice, as it would otherwise not alter the reasons for which the petitioner was granted bail. Stop. He also submits that since the bail was granted by a coordinate bench of this court, and there is no provision in the CRPC for modification of bail conditions which are imposed by High Court while granting bail, similar to that of Section 180 or Section
It was
the magistrate.
now 528 BNSS.
No. The magistrate court's bail order may be modified by High Court.
483 1B.
Similar to that of Section 483 within bracket 1B, where a bail condition imposed by a magistrate court may be modified by High Court. Stop. He submits that since there is no specific provision for modification of bail condition, आगत की लिखने section 483. Yes. ठीक. Last time. Hence, he submits that for the ends of justice, the inherent power may be invoked, and hence for the ends of justice, the inherent power of this court under Section 528 may be invoked. Stop. He also submits that what is corresponding to 362.
This is 403.
He also submits that while exercising powers under Section 528 BNSS in such a case, the bar provided under Section 403 BNSS would not be applicable to such cases. Stop. Learned On the other hand, learned additional public prosecutor, Mr. B. Sharma does not opposes the prayer on the ground that if the modification which is sought for by the petitioner is allowed, it would not change the other conditions imposed on the petitioner in any manner, and therefore it would not make and therefore it may be allowed. Stop considering the submissions made by learned counsel for both these sides. This interlocutory application is allowed, and the order dated 28/5/2025 passed in bail application number 1464/2025 is modified to the extent that the sureties, two sureties for bail of the petitioner need not to be from Sri Bhumi district. Instead, they may be any person residing within the state of Assam. With above observation, this interlocutory application is disposed.
Obliged.
For withdrawal, production is 31.
Made, please. Am I allowed to withdraw lordship?
Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Highly obliged. Obliged.
Item 13.
Lordship, pursuant to the last order, your lordship, the PP was requested to inquire about the service of notice to the respondent.
That service has,
Also, we have not received the instruction in right, Lordship. The office note also suggests, Lordship, the service report has not been received. Lordship, if Lordship permits me one more time, Lordship, I can try again, or else I might just be appointed, Lordship.
short date, Tuesday.
Lordship.
Heard Mr. H. Majumdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who seeks some more time to get information regarding fate of the notice issued to respondent number 2. The prayer is allowed. Let this case be listed on 12th.
Also, the registry may take note if they receive any notice also, Lordship.
Service reporter.
Yes, they may receive in the meantime.
Okay. Well, in the meanwhile, registry shall also put up a note if it receives the service report in respect of notice issued to respondent number 2.
The prosecution witnesses, they are not cooperating. Lordship, last 25 dates, they have not appeared. I have annexed all the orders of the trial court.
Who has not?
If prosecution witnesses, continuously the learned trial court is issuing fresh summons to the prosecution witnesses, but they are continuously being absent.
Let us see regarding report. Otherwise, on that day, we will appoint one
Yes.
amicus. We'll wait.
Item 14.
Right, Mr. Lordship. Lordship, in the last order, CD was referred to in place of LCR Lordship.
Is there?
No, Lordship, this is charge sheeted matter. LCR may be called for.
Is a charge sheeted matter? Okay. Heard Miss Otoli Kitts, your learned counsel for the petitioners. Also heard Miss M. Deka, learned counsel for NCB, who submits that in this case, charge sheet has already been laid. So in view of the aforesaid submission, let the scanned copy of the case diary, scanned copy of the trial court records be called for, along with the scanned copy of the case diary. The registry to issue requisition for the same. List this matter on 29th of August.
Highly obliged.
Item 15.
Yes.
So 483 application, my lord. I am arrested on my lord 14/6/2022. Today is 52 days, my lord. Allegation against me, my lord 3085 of BNS and read with section 10 and 13 of UAPA. FR is page 16, my lord.
308.
Yes, my lord, 3085.
What is the offense?
Yes, my lord, that is 3085, my lord, extortion, my lord. And UAPA, my lord. Yes, may I read, my lord?
Yes.
Subject affair regarding threatening, false and extortion. Respected sir, I, the Anderson, I am a businessman by profession and run a small retail and cycle repair shop. Easygo Cycles at Moran. I would like to lodge a complaint regarding a serious matter involving threats and extortion attempt made against me and my family. On 4/6/2025, my wife Srimati Krishna they received in her number so and so two WhatsApp voice message and today a WhatsApp call from the mobile number so and so. The caller introduced himself as a Major Adjournment from the Ulfa Independent and made a monetary demand. The caller claimed to possess full knowledge about my family, including details of my school-going son. To prove his claim, he sent a photograph of my shop from residence through WhatsApp and further stated that there were 9 persons involved with him. He also said that he would call again tomorrow between 9 a.m. and 12 noon. He clearly said that if we do not fulfill his monetary demand, the consequences would be harmful for me and my family.
Now, what is your submission?
Yes, my submission, my ground of arrest, my lord, kindly come to their page 19. They have stated about my arrest, my lord. Why they arrested me, my lord. I am Sofiuddin Ahmed, my lord. Page 19, my lord.
Yes.
Number 1, my lord, your mobile contact with the Alpha Major Adjournment Assam who demanded money from the victim of this case. And many business persons of Dibrugarh district have received similar extortion demand from Ulfa Major Adjournment Assam. This is demanded by Adjournment Assam. Now, my lord, to your land mafia who was earlier arrested for capturing land of poor victims by force and buying land in very low price by putting them in fear of life and property, previously case registered against the arrested person for his illegal activities by so and so. For previous record, they have arrested me, my lord. Now 3 number, my lord, this is Cesar, my lord, from my home, my lord. During the search of your house, blank stamp papers of ₹20, non-judicial stamp papers with only the signature of the 4 landowners are found, which clearly indicates that by using your influence and power by threatening 4 persons to forcefully signing the blank stamp paper and capturing the land of 4 by deceitful means. From where UAPA come? And my lord, 4, my lord, 4 point, my lord. Next page, my lord, page 20, my lord. That is also, my lord, interesting. The victim of this instant case has a plot of land where he has a rented house being occupied by one woman, Bonti Soikia. This woman has not vacated the rented house, even after repeated requests by the victim informant of this case. This Bonti Soikia has been in contact with you, and that is Sofiuddin Ahmed, that is me, my lord. And you are providing her all sorts of support to make her capture the land and the house of the victim of this case. Investigation revealed that when the victim of this case denied to leave away the plot of land and the house to the women. Bonti Soikia, her mastermind, you contacted Ulfa Major Adjournment Assam and asked him to threaten the victim of this case to hand over the plot of land. Accordingly, Adjournment Assam demanded the money and also the land from the victim while making calls over WhatsApp with me. From my lord, this ground of arrest, from I was connected with my lord Adjournment Assam. And my lord, from if the Bonti Soikia disturbed the victim, my lord, they have never filed FIR regarding this matter, my lord. All are concocted story, my lord. And if your lordship kindly come to page 21, my forwarding report, my lord. Yes. Forwarding report also same, my lord.
Now, what is the submission?
Yes, my lord, I have no way connected in this matter, my lord, on UAPA, my lord.
Okay.
That is only mobile phone. How can test, my lord? That is, my lord, that question. I am involved in another case, my lord. Therefore, my lord, they have arrested, my lord. And my lord, there is no embargo also, only 10 and 13, my lord. 43 D5 have no embargo.
Yes,
Malat,
he has
first grounds, Malat, yes. First,
contact with this
Adjournment Assam.
Adjournment.
Yes, and he is booked under section 10 and 13 of the UAPS. So 10 states for the penalty for being a member of the unlawful association, etc.
2 years.
The unlawful association, who may be the unlawful association, Malat, is and continues to be a member of the such association, take part in meeting of such association, or contributes or receives or solicits any contribution for the purpose of such association. So this is coming. Now, punishment under 13 is up to 7 years. Now, this person, Malat, is a veteran land mafia. Though in the Malat grounds of arrest, 2 cases has been given. Now, under 1 case, another case is under investigation. 2 cases was succeeded. All are Moran PS. Moran PS case number 25/22, that is succeeded. Dibrugarh PS case number 90/23 succeeded. Now, Moran PS case number 58/25, that is under investigation. Malat. Another case, 58/25 is under investigation. Now, this person, Malat, has link with Adjournment Assam, Malat, and their Malat witness of other persons also, Malat, who got those Malat letter from Alpha, Malat, for demanding money. Now, when this person's investigation is going on today is around 52 days, 53 days, Malat. Now, police has, Malat, during this investigation time, Malat, when he is arrested, Malat, in Moran district, a specific note has been given by the IO that after the arrest of the Safiuddin Ahmed, not a single extortion call from Alpha Independent had yet been reported in Moran PS. Thereby, Safiuddin had provided all information to Alpha for extortion with Moran PS and its outskirts. So, Malat, he is giving the information, and it was called by those persons, Malat. And Malat, he threatened the persons, Malat, other witnesses also give statement, Malat. They also threatened, they have also got those extortion letters, Malat, and call demanding money. And fact is that their land has to be, Malat, forcefully taken by this person, Malat.
What is the punishment for 3085?
3085, 10 years.
Extended 10 years.
10 years.
Extended 10 years.
Investigation is still going on, and
very interesting. Page 23, my lord. Is Alpha is involved for capture land? There is very interesting. Page 23, my lord. Kindly see, my lord. Page 23,
No.
para 5.
no, that is not my contention. Malat, he gave the those phone numbers. Call from Malat, Alpha has come, Malat, and demanding money and giving the threatening, Malat. He want to grab that land, Malat. And
Page 23, era 5, my lord. May I read, my lord? Page 23. It is very interesting, my lord. Dear ground, my lord. Era
Okay,
15.
keep an additional public prosecutor. this application under section 483 of BNSS has been filed by the petitioner, namely
Tofiuddin,
Tofiuddin Ahmed, who has been detained behind the bars
from 14/6/2020.
in 6/2025 within bracket for last 52 days in connection with Moran PS case number 62/2025 under section 308 within bracket 5 of BNS, read with section 10/13 of unlawful activities within bracket Prevention Act 1967. The gist of accusation in this case is that on 5/6/2025, one Dhitri Sundar Day had lodged an FIR before the officer in charge of Moran Police Station, inter alia, alleging that he has received threat calls over mobile phone from a person, threat calls for extortion over a person, over mobile phone from a person who had identified himself as Major Adyaman Assam of Alpha Independent. It is also alleged in the affair that the caller demanded money from the informant and threatened the informant that if he does not pay the money, his family would be harmed. Learned counsel for the petitioner has submitted that petitioner has not been named in the affair and he is in no manner involved in this case. He submits that the grounds of his arrest in connection with this case, as shown in notice under section 47 of BNSS, which was furnished to him at the time of his arrest, indicates that the police found, the investigating office agencies found him contacting with Alpha I Major Adyaman Assam. He also submits that the other grounds shown in the section 47, shown in the notice under section 47 are not connected with the allegations made in the FIR, like accusing the petitioner to be a land mafia and tendency of other cases against him. He also submits that seizure of stamp papers, blank stamp paper, were also shown to be grounds for which he was arrested. Learned counsel for the petitioner submits that the grounds of arrest communicated to him does not have any link with the accusation made against him in the FIR. Accusation made in the FIR by the informant. He also submits that the petitioner has already been detained behind the bars for last 52 days. And considering the period of detention, the petitioner may be allowed to go on bail. Stop. On the
Sorry, madam, there is a blank stamp paper with signature of poor land or not, madam?
with signature blank stamp papers
With signature of
with signatures of poor
Poor
landowner or poor landowners. On the other hand, learned additional public prosecutor Mr. K.K. Parashar has produced the case diary of Moran PS case number 62/2025 and has vehemently opposed the grant of bail to the petitioner. He submits that there are sufficient materials in the case diary to indicate that the petitioner is helping the proscribed Alpha I organization in extorting money from poor people. His learned counsel for the learned additional public prosecutor submits that the petitioner is also a land mafia.
Madam.
There are materials
You
in
get
the
already suspected and
case diary to indicate that several cases where accusation of grabbing land illegally was made against the petitioner have been charge sheeted, and one, how many have been charge sheeted? Two cases.
Case 19, my lord.
One Moran case was still pending. Madam.
One has been charge sheeted
Suspected.
instead of several, two. And one case is still pending investigation. What is this letter?
But extortion.
Extortion note.
Letter to other persons also. Madam.
He also submits that there are also material in the case diary to show that the petitioner had also provided information as well as phone numbers of some other persons to the proscribed organization Alpha within bracket I. And extortion notes were sent to such persons by the said organization. I have considered these, you have flag mark. I have considered the submissions made by learned counsel for both sides. On perusal of the case diary, it appears that there are sufficient materials against the petitioner therein. And considering the incriminating materials, this available in the case diary against the petitioner, as well as nature of the offense involved, this court is reluctant to grant bail to the petitioner at this stage. Accordingly, the prayer for bail is rejected. Send back the case diary.
Item 17.
May it please the Lord. Regular bail application matter. Charge sheeted under section 8 of the POCSO. And my lord 75 of the BNS Act.
It is sexual assault.
Yes, sir.
One thing I'd like to point out, my lord, as per the office note, my lord, as per the office note 5/25, no steps taken, my lord. We have not gone through the last scan. Now he has appeared, my lord, we have to go through the.
Yesterday I have.
You are engaged counsel. You are opposing. Opposing or not opposing.
But I have not gone through because as per the office note, steps not taken, 5/28/25. So my lord, now he has filed, my lord. But we have to,
Now, what is the submission?
I have not gone for that.
Gone through what?
Scan copy, my lord.
Okay.
On
You are seeking time.
maybe in the second half, I can do, but.
Let him go through.
Well.
Let him go through the records. We'll take it up in the second half.
Item.
Item 18.
For it, you have, DNS is your lordship. And this is the intermediate quantity and the accused persons are arrested on 4th of July. And the FIR is page number 8.
4th July.
FIR is
How
page-
many days?
But he did not receive, my lord. I am seeking another date, my lord.
Page is the FIR, your lordship. The articles are not recovered from the possession of the accused person. It is recovered from one public vehicle, Mahindra, your lordship, Mahindra Magic vehicle. It is the public vehicle and your lordship, not only the accused person owns it on the day on this vehicle, your lordship. So kindly bail may be allowed. And it is the intermediate quantity and the accused person.
Intermediate quantity of what? Heroin. What was the contraband? How much?
50 grams, your lordship. Caesar list, if your lordship. Inventory list, your lordship.
53-gram heroin is too much. Why he was arrested?
4/7.
47.
No, why? He was not in the vehicle. Where is the forwarding report?
Forwarding is here, your lordship. Page number
34 days. When can you produce the case then?
That's from Nunmati.
yes, lordship. And they are the local person, your lordship.
Immediately after 15, my lord. 19.
Heard Miss Ed Medhi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that who prays for some more time for producing the case file. Case diary. The prayer is allowed. Let this case be listed on 19th of August. Nineteenth August.
Finding item 9.
Yes.
It is a proceed.
I'm
Yes.
appearing in item number 21. 21, 22, and 9 from the same.
Okay, we are taking up 9 first. Item number, or which item should we take? So let,
Paying the section 47. That is the main one.
okay. So what is the submission?
Okay. In the notice of 47, no ground of arrest was mentioned. 48 also. Notice of 47, 48, and arrest memo, no ground of arrest was mentioned.
Where are the, in item number 9, where is the? Nothing.
The 47 notice, your lordship. Only the case number and sections are mentioned.
Number 2. Case number 2.
26.
Yes.
This is the notice, lordship, section 47 notice.
Is not there.
But lordship, here in this, I have I made my submission in earlier cases that those section 47 notice does not elaborately mention everything, all the section, all the offenses he has particularly mentioned. Even though it is as on that lordship, as there are some judgments of honorable apex court of constitution bench lordship, those are all till that those are holding the field lordship. As it is a 5 judges bench, 6 judges bench, and 4 judges bench judgments are there lordship. Even though lordship, in this case lordship, particularly in this case lordship, I have some another submission lordship, that is the judgment of Kasireti lordship. The honorable apex court has passed lordship in the case of Kasireti lordship.
Kasireti.
Kasireti lordship. In para 28 lordship. May I read that para?
We will require the copy of that.
Yes, para.
Kasireti. What it says?
Lordship, may small paragraph.
Yes, you read.
For the purpose of clause 1 of the article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The grounds to be communicated to the arrested person should be somewhat similar to the search framed by the court for the trial of the case.
Yes, that means particulars of offense, that you were found in possession of so and so on so and so date, has to be there. Merely stating the case number and penal provision is not sufficient.
Here it is not necessary for the authority to furnish full details of the offense. However, the information, there are para 36. Para 36 lordship. If a person is arrested on a warrant, the grounds for reasons for the arrest is the warrant itself.
Yes.
If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed of the grounds for his arrest. If he is arrested without a warrant, in our case, he must be told why he has been arrested. He must be told. If he is arrested for committing an offense, he must be told that he has committed a certain offense for which he would be placed on trial. In order to inform him that he has committed a certain offense, he must be told of the acts done by him which amounts to the offense. He must be informed of the precise acts done by him for which he would be tried.
You are helping the,
That is, I'm coming to my point. Lordship.
yes.
So, lordship, here in this case, lordship, honorable apex court has appointed lordship. He must be told why he has been arrested, and that when it is
Which para it was?
36 lordship.
Okay.
So, Lordship, it is Lordship, as per this paragraph, Lordship, he must be told means Lordship, there is not the requirement of Lordship furnishing him the written ground of arrest, Lordship. So why, how he, now we have to prove how he has been told. So Lordship, from CD we have to prove, Lordship. In the CD,
No,
Lordship,
no.
there is- Lordship.
Written grounds of arrest has been settled.
So this is also the apex court judgment, Lordship. This is also.
This does not say that it is not required. Written grounds of arrest is not required.
But when it is specifically says, Lordship, that he has to be told, then can we meaning thereby, Lordship, he has to be informed, written ground of arrest is required.
Other judgments which are holding the field have already settled that law, that it has to be in writing.
The requirement article 22(1) is that, Lordship, he must be informed why the ground of arrest, Lordship.
So
When
your
the-
submission is that in writing is not necessary.
Lordship, as per this judgment, Lordship, judgment is for this is also a two judges bench of the same constitution bench, same strength judge.
Where it says that written is not necessary.
The language says, Lordship, that when it is specifically says, if a person is arrested, he has to, if person is warrant on a ground for reasons for arrest, is the warrant itself, if the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed on the ground for his arrest. If the arrest without warrant, he must be told why he is being arrested. Then if the, can we meaning the Lordship, he must be told, can you mean, we cannot mean the Lordship that he must be told he must be furnished with the written ground of arrest, Lordship.
Okay, so gist of your submission is that
Lordship,
in writing it is not
it's
necessary.
not required, Lordship, when the article itself says, Lordship, the ground of arrest is to be mentioned, is to inform him, Lordship. Then we have to, when we can show him and that whether it is complied or not, whether it is being informed or not. So, Lordship, from the paragraph, from the IO note, Lordship, it is mentioned, Lordship. I have found it, Lordship, here in the Lordship, IO note, Lordship. Proper থাকে যে এই that this not make any decisions.
I'll record your submissions. That there is an endorsement in the case diary regarding furnishing grounds of arrest.
In that case, Lordship, it is not, Lordship, may kindly give me some more time, Lordship, because Lordship, I have already earlier cases, Lordship, I have submitted some written submission of in regard to my.
But that has been decided. That has been decided. The judgment have been delivered. So unless you appeal again, in which your submissions were not acceptable, found to be, so unless you appeal against that.
But when, Lordship, my specific here in this case, in those cases, Lordship, the facts are something different, Lordship. In those cases, Lordship, this I was not there, Lordship. But when in this case, Lordship, custody is covered, why we are only going by the judgment of the Honorable Pihan Kumar, Lordship. The Pihan Kumar judgment, Lordship. Why we are not going to the, why we cannot go to the judgment of the custody and other judgments, Lordship?
No, where Kashiradi is, how you are reading a judgment, where Kashiradi says that written, it is not to be informed in writing, or is there any indication that
that paragraph indication is sufficient, Lordship, when the judgment itself says, Lordship, if he is being told, when he has to be told, it is a specific word, he has to be told, Lordship, then, Lordship, whether it is not sufficient for him to understand, Lordship, for us, Lordship, this is the this is on verbal information is also required, and that too supported by the case diary, Lordship.
okay, heard Mr. What is the name? R.A. Majumdar, learned counsel for the petitioner. Also heard Mr. P.S. Locker, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Muhammad Shah Jahan Mullah, who has been arrested on 22/2025 in connection with Mornoy PS case number 17/2025 under section 123 of BNS, read with section 22C/29 of the NDPS Act. The gist of accusation in this case is that on 20 where is the FIR?
Page 13.
On 22/2025, one Sharat Chandra Nath, SI of police, had lodged an FIR before the officer in charge of Mornoy police station, inter alia, alleging that on receipt of an information through reliable sources regarding transportation of suspected drugs in a Maruti Swift Desire vehicle bearing registration number AS01FB 5499, a police team was constituted and a Naka checking was arranged. Naka checking was organized at Harimura Borjuli. Stop. During the Naka checking, the aforesaid vehicle was intercepted and 3 accused persons within bracket, including the present petitioner, were apprehended therefrom. During search of the said vehicle, what was the total contraband?
706 number of
706 numbers of bottles of cough syrup containing codeine phosphate were recovered. Stop. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on the ground that no grounds of arrest were communicated to him at the time of his arrest or to his family members when he was arrested. Stop. Learned counsel for the petitioner submits that though notice under section 47 was served on the petitioner, however, it did not contain any ground for his arrest or the basic facts which necessitated the arrest of the petitioner. Stop. He submits that the fundamental rights of the petitioner guaranteed under Article 22 within bracket 1 of the Constitution of India has been violated in this case, as no ground of arrest were communicated to him no ground of arrest was communicated to him. In writing, Vihan Kumar Dioksan, in writing, as clarified by the apex court. You're relying on
Vihan Kumar,
verified
para 40.
in the case of Vihan Kumar versus State of Haryana and another reported in 2025 SCC online SC 269. He submits that in the aforesaid case, the apex court has observed that when there is violation of the constitutional requirement of furnishing grounds of arrest to an arrestee at the time of his arrest, such an arrest itself becomes illegal, and on that ground only he may be allowed to go on bail. Stop. On the other hand, Mr. P.S. Larker, learned additional public prosecutor, has produced the case diary of Mornoy P.S. case number 17/2025 and has vehemently opposed the grant of bail to the petitioners on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable to this case. He also submits that he also, relying on the judgment on the apex court, he also, relying on the judgment of the apex court in the case of Kashi Reddy Upendra Reddy versus State of Andhra Pradesh and another. Reported in 2025 INSC 768, has submitted that if the petitioner is told at the time of his arrest as to why he has been arrested, it would be sufficient compliance of the mandate of Article 22 within bracket 1 of the Constitution of India. He submits that in view of the judgment of the aforesaid judgment of the apex court, there is no requirement of furnishing written grounds of arrest, no requirement of furnishing grounds of arrest, in writing, if the petitioner has been otherwise told about the said grounds. He also submits that in the case diary, the investigating officer has made an endorsement to that effect, that the petitioner was communicated with about the grounds of arrest.
Under what grounds? All the grounds has also been mentioned.
Communicated with the grounds of arrest at the time of his arrest. He also submits that all the grounds for which the petitioner was arrested has been communicated, as would be clear from the perusal of the said endorsement made in the case diary. He therefore prays for rejecting the application for bail.
36 is clear.
Uh,
Para 36 of the state judgment. Custody.
Para 36, which portion you are relying? On that I have mentioned that the phrase told, if he is told, that you are interpreting as he has to be told.
If the arrested he must be told.
If he's, that means you are saying that if he's told, there is no necessity of giving, communicating grounds in writing.
Para 27 also it is mentioned specifically also.
What?
The object underlying the provisions that the ground of arrest should be communicated to the person arrested has been very successfully explained in Bihan Kumar Supra. On hearing about the grounds for arrest, the person concerned will be in a position to make an application before the appropriate court for bail or move the High Court for the writ of habeas corpus. Further, the information will enable the arrested person to prepare his defense in time for the purpose of his trial. For these reasons, it has been provided by the Constitution that the ground for arrest must be communicated to the person as soon as possible, subsequently to pay for the purposes clause 1 and 2, it is not necessary for the authority to furnish full details of the offense. Even if you go by that 47 notice is also there, which has been communicated to him, that it means for the purposes of clauses 1 and 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense.
What is to be furnished then?
Information should be sufficient. Information should be sufficient.
Learned counsel, learned additional public prosecutor also submits that in the case of Kashi Reddy, Upender Reddy, within bracket Supra, the apex court has held that for the purposes of complying with the provision of mandate of Article 22(1), it is not necessary to furnish full details of the offense alleged against the arrestee. It would be sufficient compliance if sufficient information has been given to him regarding the grounds of arrest, which would enable him to engage a counsel of his own choice.
That also I have found, and I am searching that also if there is some endorsement in the city regarding his information, that is also sufficient. That I am searching also.
Okay. I have considered the submissions made by learned counsel for both sides and have gone through the records of, gone through the case diary, which was produced by learned counsel, learned additional public prosecutor. Remaining after lunch, we'll continue.
I just want to that a matter is listed for tomorrow for withdrawal.
Okay. Yes. What was the talk?
Prior to starting, before starting, may I?
Okay, okay.
Before starting, may I please one paragraph from the Bihan Kumar Dorsi, which says regarding the issue also now as
Yes.
in Bihan Kumar in para 18. Married, Lordship. Variety.
Yeah.
Married.
Yes.
In the present case, first respondent relied upon an entry in the case diary allegedly made at 6:10 PM on Iman, which
Para
para 18, Lordship.
18. Which citation?
Lordship, this is Lordship 2025 SCC online 269.
আসেনি বিহান কুমার আরো এটা আছে in the online
Yes, it is different from SCC.
SCC, though companies same SCC, but for different. Yes, para 18.
Para 18, Lordship. From third line, Lordship. Third line, last part. Fourth line, last part. Weird. I can read from the beginning. In the present case, first respondent, Lordship got it.
Yes.
In the present case, first respondent relied upon an entry in the case diary allegedly made at 6:15 PM on June, which records that the appellant was arrested after informing him of the grounds of arrest for the reasons which will follow hereafter. We are rejecting the argument made by the first respondent. If the police want to prove communication of the ground of arrest only based on a diary entry, it is necessary to incorporate those grounds of arrest in the diary entry or any other documents. The ground of arrest must exist before the same as informed. Therefore, it is in a given case, even assuming that the case of the police regarding requirement of Article 22(1) of the Constitution is to be accepted based on an entry in the case diary, there must be a contemporaneous record which records that the ground of arrest when arrestee pleads before a court that grounds of arrest were not communicated. The burden of proof to the compliance of Article 22(1) is on the police. So here it is said, Lordship, to my understanding, Lordship, when they have stated, Lordship, they stated as we have not communicated the ground of arrest, then it is the burden shifted to us that how we can prove that yes, we have proved it. We have furnished to him the ground of arrest, and it has to be in the diary and not simply stating that ground of arrest has been communicated to him. It has to be how the ground of arrest has to be. So, Lordship, here in our case, why I am arguing on this case, specifically in this cases, Lordship, even after knowing that Lordship has already rejected such kind of argument, that Lordship, here in this case, specifically in this case, Lordship, that part, that grounds of arrest, that you have something has been recovered from him, this is a non-NDPS case, this is not this is a illegal article, that all has been specifically mentioned in this in that endorsement also.
And
So Lordship, when our burden shifted to us, we can prove it that yes, that has been communicated to him.
how you are proving that it is communicated?
That is why, Lordship, because Lordship, that this section, this paragraph has stated, Lordship, if that is everything is elaborately mentioned in
Case diary.
section 47 notice, then this paragraph has nothing to do. It is only when this paragraph will come when that is not mentioned in the 47 notice, as well as it is not mentioned in the case diary. So, Lordship, now if burden is shifted to us, then we are going to prove it from the case diary, that how it has been mentioned.
How? Tell me how.
Lordship.
Suppose you have mentioned the grounds in the case diary
Lordship.
and there is no contemporaneous record or other document showing that you have communicated it. It remains in the case diary.
47 notice is there, Lordship, that it is not.
It is blank.
Bihan Kumar,
47 notice is a blank notice.
in Bihan Kumar case, there was no notice itself, Lordship. In Bihan Kumar case, that
No.
notice itself was not given. In Tobirpur case, that was also not given, Lordship.
No,
But
what you
in our
want to,
case,
what you want to say,
now I am saying,
there,
Lordship, that
that if you mention the grounds of arrest in the case diary,
Lordship,
That is sufficient compliance.
Because Lordship, when burden is shifted to us, we have to prove it. And
How you are proving? Tell me
because Lordship, because this specifically this paragraph has stated, Lordship,
what it has stated.
the ground of arrest must exist before the same as informed. Therefore, in a given case, even assuming that the case of the police regarding a requirement of Article 22(1) of the Constitution is to be accepted based on the entry in the case diary, there must be contemporaneous record which records that the ground of arrest were when the arrestee pleads before a court that ground of arrest were not communicated. So, Lordship, our one document is there, Lordship, when person is caught red-handed, that has already been argued, Lordship. Now I'm not going to argue on that point, Lordship. When person is caught red-handed, he
No,
himself
that
knows
has been settled.
that is settled before this court, Lordship. I'm Lordship. Because, Lordship, apart from that, Lordship, Lordship, when that notice has also been given, and apart from that, when I has specifically endorsed in the case diary that he has informed him that regarding ground of arrest. Lordship, may kindly see, may I read that proportion if required, Lordship.
Read it.
প্রকাশ থাকে যে এই মোকদ্দমা সংক্ৰান্তত গ্ৰেপ্তাৰী পদক্ষেপক গ্ৰেপ্তাৰ কৰাৰ অন্তত তেওঁলোকক আন্ডাৰ সেকশন 47 বিএনএসএস নোটিস দিয়া হয়। গ্ৰেপ্তাৰী পদক্ষেপক মৰ্ণয় পিএস কেছৰ নম্বৰ সৈনছো গ্ৰেপ্তাৰ কৰা হৈছে ও তেওঁলোকক কিছু বিৰুদ্ধে ৰুজুৱা গোচৰৰ ধাৰা জামিন অযোগ্য বুলি জনাই দিয়া হয়। লগতে গ্ৰেপ্তাৰী পদক্ষেপক গ্ৰেপ্তাৰৰ কাৰণ তেওঁলোকৰ পৰা 1 নম্বৰ তেওঁলোকৰ পৰা 481 টা ফেনসাইড কাপ সিরাপ আৰু 225 টা ডিএস কাপ সিরাপৰ বটল অবৈধভাৱে সৰবৰাহ কৰিবলৈ যোৱাত
No. Suppose, what is the meaning of this line? Therefore, in a given case, even assuming that the case of police regarding requirement of Article 22(1) of Constitution is based on the entry in the case diary, there must be a contemporaneous record. Where is that contemporaneous record? Merely you mention in the case diary without mentioning that in the notice. Where is that contemporaneous record?
The notice itself is speaks everything. Then it is that incorporation of this subject. This paragraph is not required because in the case of Bihan Kumar, there was not a single notice served to him, Lordship.
No, how you explain? I just want to understand what you want to say.
I want.
What is the meaning of that? There must be a contemporaneous record.
Section 47 notice, Lordship.
So it is silent.
Section 47 notices may be silent, Lordship. It is may be silent, Lordship. It is not may not be elaborately mentioned.
Okay, I
So,
have
Lordship,
understood.
that my record.
In this case, the petitioner is mainly seeking bail on the ground that no grounds of arrest were mentioned in the notice served on the petitioner when he was arrested. On perusal of the said notice, it appears that, where is that notice?
26, Lord.
Said notice, it appears that in the said notice, apart from the police station case number, that is Mornoy PS case number 117/2025, as well the penal provisions, that is under section 123 BNS, read with section 22C/29 of NDPS Act. No other information was communicated which would indicate the grounds for which the petitioner was arrested in the aforesaid case. It also appears that apart from the other facts, no basic facts which necessitated the arrest of the petitioner has been mentioned therein. In the case of Kashi Reddy, Upendra Reddy, within brackets Supra, the apex court has observed that the petitioner must be communicated about the acts done by him which amounts to offense. Unless same is done, it would not amount to communicating grounds of arrest to him. It is no longer res integra after the judgment of the apex court in the case of Pankaj Bansal versus Union of India and others, reported in 2024 7 SCC 576 slash and comma Prabir Purkasta was a state within bracket NCT of Delhi, reported in 2024 8 SCC 254, as well as Vihan Kumar versus State of Haryana and another, reported in 2025 SCC online SC 269, that grounds of arrest are to be communicated to an arrestee, comma, in writing, comma, as soon as possible after his arrest. If same is not done, it would be violation of his fundamental rights guaranteed to him under Article 22 within bracket 1 of the Constitution of India, and in which case the arrest itself would become vitiated, and the petitioner may be allowed to, petitioner would be entitled to get bail on that count only. Stop. The submissions made by learned counsel for the petitioner, the learned additional public prosecutor, to the effect that, as in the case of Kasi Reddy, Upendra Reddy, Supra, the apex court has observed that after the arrest, at the time of arrest, in order to inform the arrestee that he has committed certain offense, he must be told within inverted comma of the acts done by him which amounts to offense, would mean that he need not to be communicated in writing the grounds of arrest. Is wrong way of reading a judgment, as in the said judgment there is no indication that the grounds of arrest are not to be there is no indication that the grounds of arrest are not to be not required to be communicated in writing. Stop. It also appears that the judgment of Kashi Reddy versus Upender Reddy has been rendered after the judgment of Pankaj Bansal and Prabir Purkayastha within bracket supra. This court is of considered opinion that considered view that there is nothing in the judgment of Kasi Reddy versus Kasi Reddy Upender Reddy Supra which would indicate that Supreme Court the Supreme Court has taken a contrary view from that which was rendered by it in the case of aforesaid cases of Pankaj Bansal, within bracket Supra, Prabir Purkayastha Supra, and Vihan Kumar, wherein it has clarified that the grounds of arrest are to be communicated to an arrestee in writing as soon as he is arrested, and any violation of the same would amount to violating the fundamental rights guaranteed to such an arrestee. The submissions made by learned additional public prosecutor regarding the observations made by the apex court in the case of Vihan Kumar versus State of Haryana, that if the which paragraph you are referring to?
18.
If the police effecting the arrest is wanting to prove the communication of grounds of arrest only on the base of grounds of arrest, it would be sufficient to show that an endorsement to that effect has been made in the case diary with details grounds of arrest cannot be accepted, as in the said judgment itself within bracket paragraph 18, the apex court has clarified that even if assuming that the case of police regarding requirement of Article 22(1) of the Constitution of India is to be accepted based on an entry in the case diary, there must be a contemporaneous records which records what the grounds of arrest were. Stop. However, in the instant case, there is no contemporaneous record apart from the case diary to show that what the grounds of arrest were in for arresting the present petitioner. Stop. Thus, this court is of considered opinion that no, before that, this court intends to clarify that the proposition of law regarding the necessity of furnishing grounds of arrest in writing has laid to rest, has been laid to rest, has been settled by the aforesaid judgments of the apex court, within bracket, Pankaj Bansal Supra, Prabir Purkayastha Supra, and Vihan Kumar Supra. Any attempt to give an give some other interpretation, any attempt to give other interpretation to the provision contained in Article 22(1) of the Constitution of India, as well as Section 47 of BNSS, would amount to diluting the constitutional mandate as provided under Article 22(1) of the Constitution of India and as clarified by the apex court in the aforesaid judgments. Stop. In view of above discussion, this court is of considered opinion that in the instant case, the notice served on the petitioner under Section 47 of the BNSS is devoid of any ground of arrest, and accordingly, the constitutional rights, the fundamental rights of the petitioner has been violated in this case. And on that count itself, he is entitled to get bail for the reasons mentioned above. What was the contraband?
7006 number of cough syrup.
For the reasons mentioned herein above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned special judge Gwalpara, with following conditions. Trial condition, Pastamana say. 5 trial conditions are there. 5 trial conditions are there. Abhishek said. This bail application is accordingly disposed of. In other 2 cases, similar or same case?
Same case. Same affair.
Same affair.
Same.
Date of arrest?
Same. Everything same.
Then everything. Item number 21-23.
Regarding para 18, there is my submission is that lordship that the ground of areas mentioned in the case diary, as it is elaborately mentioned, that is the contemporaneous record.
No. Okay, I'll record your submission.
Because lordship, it is mentioned.
No, what Apex Court has said that what I have understood, so that you can make proper submission next time. When you mention in detail the grounds of arrest in the case diary, and if you are relying on the entry made in the case diary, police is relying on the entry made in case diary, there must be some contemporaneous record. That means apart from case diary, some other record which show that you have communicated those grounds, which in this, you go through the judgment later on. I will make some edit.
I'm maybe wrong. But there must be a contemporaneous record, which records what the grounds of arrest were. So also that is why I'm saying that I thought also this is the contemporary records, and as it is mentioned that what the grounds were, that is why it is submitted. Does it make any?
You have an option to go on appeal to Supreme Court. Okay.
Item 21, essay is wrong.
21, 21 and 9. And item number 22, same order, except the name of the council. Your name is there in the cause list. 21 SH Rahman and 22 S Islam. Others will be as it is.
All right.
17.
Item 17.
Item number 17.
None has appeared for the petitioner on call. I believe we'll take it after some time.
Item 20.
May I please lordships? This is for 83 petition, my lord. The case, my lord, though, in the case, my lord, kindly have a look at page, my lord, page 12, my lord, the FIR. Page 12, my lord.
Yes.
My lord, petitioner was arrested on my lord when 23 and on forwarded on my lord 24/6, my lord. As on today, my lord, 46 days, my lord, behind the bar. And the my lord, section relates in this case.
60 days offense.
Yes, my lord.
Still, case diary would be necessary.
Yesterday we got a letter from the IO that the CD was in the session just good because of that. He sent the runner to take back the.
When can you produce? Next week.
My lord,
Heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. 13, let this case be listed on.
my lord, on if possible, 11 or 12. 11.
11.
My lord,
11 is Monday.
Otherwise, my lord, on then my lord, 12, my lord. Otherwise, my lord, already for 46 days behind the bar, my lord. That's why statutory period is 60 days, my lord, and that's why I'm paying, my lord.
No, let it be on 13.
My lord,
13
obliged, my lord.
or after Independence Day.
My lord. 13, my lord, obliged, my lord.
Okay.
Item 24. May I please, your lordship? The 43 bail application, lordship. FIR, your lordship, will find a place. Lordship. 9, lordship. The gist of the case is that, lordship, while some cattle were carrying from the Lakhimpur district to Nagaon, lordship, they were intercepted in Borgaon PS, lordship.
And while
What is the date of your arrest?
arrest lordship on 11/7 lordship. They have been arrested on 10/7 and quoted on 11/7 lordship. As on the 27 days jail custody, and your lordship has already granted interim protection to the cattle owner as well as the vehicle owner, and subsequently they have been appeared lordship and produced all the documents lordship. The cattle is not stolen cattle is stated in the FIR lordship. Because of lordship, the driver has failed to produce some cattle purchase receipt lordship. As on 39 numbers of cattle were recovered by the police, but the driver has produced only 34 numbers of cattle purchase receipt lordship. So 5 numbers are missing lordship. Now the cattle owner has appeared before the IO as directed by this honorable court lordship, and they have produced all the documents lordship.
You are the driver.
Driver and handyman lordship. They are driver and handyman lordship. At 27 days jail custody lordship. So further custodial integration may not be required lordship.
Yes.
First, I want to state that as my learned friend has already stated that there are 39 receipts which are produced before the IO lordship, and 34 are there, but the in at present lordship there is 39 is there. But one IO notice there lordship, the police will verify in the Panchayat's official sale receipt book lordship. They are found to be fake lordship.
What is found to be fake?
The receipts they have given to the police lordship. 34 receipts they have been given. He has also stated that in the FIR also stated that lordship. They have produced 34 receipts, sale receipts lordship, but they are fake.
There is a serial number.
That is
Then you pray for cancellation of their anticipatory bail. Anticipatory bail was granted to the owner on the ground that he had purchased. They have not produced. They are the driver and handyman. Who produced this?
5 is there lordship. 3-5 is there.
You need their further custodial interrogation. 20.
According to him, 35 is genuine.
According to me, there are 39.
Yes, 39. They have produced
39 cattle are
39
there.
cattle, yes.
However, the petitioner
The
has,
driver looking for
driver
35
has
number
shown
cattle was
34. That are also not genuine. I am on that lot. That means nothing, no genuine documents are there. Lord.
In that case, lordship, there should be a report call from the Mohalla market Mohalla lordship. But there is a serial number and the book number lordship. They also kept a carbon copy of the receipt they have issued lordship.
Okay. Heard Mr. T. Sutia, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application.
Mohalla lordship, the Lanet Court has already granted interim jima of the seat cattle as well as the vehicle lordship.
This application under section 483 of BNSS has been filed by the petitioner. Who are they? So many petitioners?
This is the driver and helper lordship. There's nothing to do with the
How many vehicles?
one vehicle.
So many drivers?
No, lordship, one driver, one was a petition number one is the driver lordship, but phone numbers are there, the handyman and helper lordship. And no one also claims
Petitioners, namely Anwar Hussain, Jamiruddin, Mujahidul Islam, Guljar Hussain, and Abdul Falan, who are detained behind the bars since 11/7/2025, within bracket for last 27 days, in connection with Bihali PS case number 68/2025 under section 303 within bracket 2/317 within bracket 2/3 within bracket 5 of BNS 2023, read with section 13 within bracket 1 of Assam Cattle Preservation Act 2021, read with section 11 within bracket 1 within bracket D of the Prevention of Cruelty to Animals Act. The gist of accusation in this case is that on 10/7/2025. One. S. Hajorika, SIF Police had lodged an FIR before the officer in charge of Behali Police Station, inter alia, alleging that on receipt of an information regarding transportation of stolen kettles in a vehicle, a search team was constituted. And a vehicle bearing number AS202DC 5929 was intercepted. Stop. During search of the said vehicle, 39 cattle were found, whereas the driver and helpers in the said vehicle would produce receipt of 34 number of cattle. Stop. Learned counsel for the petitioner has submitted that the petitioner number 1 is the driver of the seized vehicle, as well as other petitioners are helpers and handymen of the seized vehicle. He submits that the seized cattle were purchased by whom?
One Abdul Motin. Abdul Motin.
One Abdul Motin. Where is his bail order?
Bail order.
One Abdul Motin. Stop. Learned counsel for the petitioner has submitted that the said Abdul Motin and one Abu Taher. Who is Abu Taher?
Abu Taher is a vehicle owner also.
Abdul Motin and Abu Taher. Who is the? What happened to this bail application ultimately?
After getting this application, they appeared before the IO also, and the statement has been recorded, and they produced the documents also.
Okay, Abdul Motin and Abu Taher, who is the owner of the seized vehicle, were granted interim protection by this court in connection with by this court on 28/7/2025 in AB case number 1733 of 2025. Stop. Learned counsel for the petitioner has submitted that the petitioners, the owner of the cattle as well as owner of the vehicle were granted interim protection have appeared before the investigating officer and have produced the documents of ownership as well as other necessary document and have cooperated in the investigation. It is further submitted that the seized cattle, Jimma was granted.
Yes, granted.
It is further submitted by learned counsel for the petitioner that the owner of the cattle was granted Jimma of the seized cattle.
Vehicle.
And the owner of the vehicle was granted Jimma of the seized vehicle. In view of the aforesaid facts, he submits that further custodial detention of the petitioners may not be necessary. On the other hand, learned additional public prosecutor has produced the case diary of Behali PS case number 68/2023 and has opposed the grant of bail to the petitioners on the ground that there are materials against the petitioner in the case diary. He also submits that during investigation, it was found that the receipt
Produced by petition number 1.
produced by petitioner number 1 before the investigating officer
Fake.
were found to be fake. He therefore submits that he therefore opposes the grant of bail. So I have considered the submissions made by learned counsel for both sides. In this case, the two of the co-accused who claim themselves to be the owner of the cattle as well as of the vehicle respectively have already been granted interim protection. So it also appears that though that the investigation has progressed fairly, considering the fact that all the petitioners are detained behind the bars for last 27 days, this court is of opinion that if they cooperate in investigation, their further custodial detention may not be necessary. In view of above, the above named petitioners are allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Vishwanath, with following conditions. Number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of. Tim?
May I please, Your Lordship? My lord, on last occasion, the Honorable Court, my lord, perused the scan copy, my lord, but the arrest memo and 47 BNSL was not, my lord, come in the scan copy. The Honorable Court directed to produce, my lord. And the similar situated person, my lord, already released on bail on the ground of 47 was not communicated, my lord. So, my lord, I have collected from of my own capacity, my lord. So, I think
You give a copy to PP. Who is Jahidul Islam?
Last occasion released on bail. And co-accused.
Co-accused in this case?
Yes, ma'am.
Yes.
Before Your Lordship is Bimal Rava and Rostam Rava. 1 year already, and they were 1 year, 9 days today.
Heard Mr. N. Uddin, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners Bimal Rabha and Rustam Rabha, who are detained behind the bars since 29/7/2024 in connection with Sessions Case number 127/2024 arising out of Agya PS Case number 64/2024 under section 126(2)/310 within bracket 3/103/115 within bracket 2/61 within bracket 2 of BNS read with section 25 within bracket 1A/27 of the Arms Act presently pending before the Court of Learned Additional Session Judge, Goalpara. The gist of accusation in this case, quote from bail application number 2158/2025, code para 3. You are behind the bars since how many days?
Well, 2 days, 1 year, 9 days. Total days, 374 days. Forwarding to report is a part of that co-accused man.
374 days for both the accused.
Yes, sir.
Code para 4 with change in the time 374. এই প্যারাতে add করিব। He also submits that in the meanwhile, two of the petitioners, two of the co-accused, namely Abhijit Basumatari as well as Jahidul Islam, have already been released on bail. Code 5 petitioner plural petitioners থাকিবে 5. Code 6 learned additional, on the other hand, learned additional public prosecutor has fairly submitted that the notice produced by the petitioner, notice under section 47 of BNSS, which was served on the petitioner, does not contain the basic facts which necessitated the arrest of the petitioners. Neither it contains any grounds of arrest as required under law. Code para 8, code para 9, 50,000 each with one surety of like amount.
God bless you.
I did 45.
This case, lordship, scan copy of the CD is not there, so it cannot be a certain lordship.
Scan copy was asked.
Lordship,
It-
there
it
are
has-
order sheets are there.
Scan copy received one and
It is received, but only the order sheets are there. CD is not there, scan copy of the CD. So 47, I cannot look it into.
Lordship, I have annexed the arrest memo and the section 50 notice, Lordship, certified copy, Lordship, as in page number, Lordship, 70 to 72, Lordship.
what is the offense?
Offense under section 21C of NDPS Act, Lordship.
Oh, scan copy of the case diary would be necessary. There may be some other documents.
As per search sheet, Lordship, I have annexed the certified copy of the search sheet, Lordship. They have not relied any other documents, Lordship, in search sheet, Lordship.
No, we will peruse the scan copy of the case diary. Heard Mr. T. Thakuria, learned counsel for the petitioner. Also heard Ms. Mr. K. Das, learned additional public prosecutor. Who submits that though the scan copy of the STFPS case number Scan copy of the orders passed in STFPS case number 4/2024 has been received. However, considering the contentions raised by the petitioner, learned counsel for the petitioner, scan copy of the case diary of STFPS case number 4/2024 may be called for. The prayer is allowed. Let the scan copy of the case diary of STFPS case number 4/2024 be called for from the trial court. Registry to issue requisition for the same. List on 21.
So actually, this is fixed for evidence lordship. In additional section number 5 lordship. I think lordship scan copy is with the PP lordship. I think lordship. So lordship, if requisition made in the NDPS case lordship, I think lordship then only came the CD or other
No,
relevant
case diary would be with the court.
in lower court lordship.
Court will take it from public prosecutors. Let us see the report, what report comes. List on 21.
Master. Item 17.
Well, this is a regular bail application matter. Charge sheeted under my lord section 8 of
Where is the amicus? Mr. Ayu Chaudhary.
Yes.
Yes.
Charge sheeted under section 8 of the POCSO Act and 75 of the BNS manual. The petitioner was the headmaster of a school manual. He is 110 days behind bars manual. My humble submission is that, my lord, since investigation has already completed, and my lord, since the petitioner, my lord, has no criminal antecedents, my lord, he himself had surrendered in the court matter. So, my lord, considering the stage of the case, my lord.
What is the stage?
Stage, my lord, my instruction was that I had checked the e-court website, my lord. There, my lord, because of the absence of my lord presiding officer, my lord, the case is fixed for production of the accused, my lord. Earlier, it was fixed for copy. At page number 28, my lord, it was fixed for copy.
Yes. Yes, Mr. Parag.
My lord, yes, Sashit submitted in this case on, my lord, 25/5/25. He being a headmaster, my lord, the victims are, there are 4 girls, my lord. All are 12, 11 of this, my lord, age, my lord. 12 years.
How many victims are there?
My lord, though initially in the, as per the FIR 1, no, they mentioned 4 girls, my lord. And there are 183 statement of the girls, my lord. Whereas, my lord, there are also one boy of the same class. He also give the 183 statement, my lord, against the headmaster, my lord. He is also 12 years old. My lord, may kindly peruse those statements, my lord, kindly. My lord, at this stage, when evidence of victim, my lord, may peruse those statements. I have to take mark.
Yes,
All
Mr.
183.
Chaudhary.
Bail application before the learned trial court. And that was rejected considering the statement recorded under 183 of BNS.
One witness is one boy of 12 years. The girls are all 12 or 11.
No, let the victims be examined first. Because there is a probability you are headmaster And they are students.
Perhaps suspended, my lord, because of the incarceration. my lord.
Still considering the age of the victims. Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, as well as Mr. I. U. Chaudhary, learned counsel for the informant, not for the informant. Learned counsel appearing for the victim. Father of the victim girl. This application under section.
Can this matter, my lord, be taken up after 3 weeks? My lord? By that time, my lord, if these statements are.
No, that would be, you come again. You need not to come again. You go to the POCSO court. I'll mention in the orders. Instead of coming to this court,
Yes,
you go to the POCSO court after examination of the. This application under section 483 of BNSS 2023 has been filed by the petitioner Omar Ali Sheikh, alias Omar Ali Sheikh, who has been detained behind the bars since 19/4/2025 in connection with special POCSO case number 48/2025 under section 75 of BNS, read with section 8 of POCSO Act 2012, presently pending in the court of learned Special Judge POCSO Kokrajhar. The gist of accusation in this case is that on 24/9/2024, one Dolumani Hukai Haloi. What is the name?
Okay, man.
Dolumani Hukai of Kokrajhar Police Station lodged an FIR. Who is the informant?
Informant is the WSI, man. SI Kokrajhar PS.
Kokrajhar Police Station lodged an FIR inter alia alleging that the present petitioner had, on 24/9/2024 at around 4:51 p.m., on the pretext of providing on the pretext of teaching the victim girl as how to solve a maths problem, had committed sexual assault on her. So, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since last 110 days, and the examination of witnesses has not yet started. He submits that considering the period of detention, he may be allowed to go on bail, and he is ready to fully cooperate in the trial. On the other hand, learned additional public prosecutor vehemently opposed the grant of bail at this stage, inter alia stating that 4 minor victims, 4 students of the school in which the petitioner worked as headmaster have have given statements, have given incriminating statements against the petitioner. He submits that those witnesses are yet to be examined by the trial court. And if the petitioner is released at this stage, there is every likelihood of the witnesses being influenced or threatened by the petitioner. Mr. I.U. Chaudhary, learned counsel for the father of the victim girl, has also opposed the grant of bail at this stage and has made submissions similar to that of learned additional public prosecutor. I have considered the submissions made by learned counsel for both sides and have gone through the records of special POCSO case number 48/2025, including the statement made by the victim girl as well as other witnesses. Considering the fact that the victim and other material witnesses are yet to be examined, this court, considering the nature of offense involved in this case, is reluctant to grant bail to the petitioner at this stage. Accordingly, the application for bail of the petitioner is rejected with an observation that after examination of victim girl and 3 students who are minor and shown as prosecution witnesses in the list of it in the charge sheet, the petitioner may approach the trial court and may pray for regular bail before the said court, if so advised.
Can an observation also be given that the trial court can expedite the trial, because since the last several dates, it is only fixed for production of the accused, no substantial progress in the
Okay.
trial.
The learned as it is submitted by learned counsel for the petitioner that the court is vacant, that the court of learned special POCSO case, special judge POCSO is vacant. The learned district judge, district and session judge, learned session judge Kokrajhar is directed, learned session judge Kokrajhar, who is also designated as children court.
Will be
Sessions.
insert special judgment, IC special.
Who is also designated as IC special, in charge special judge, as well as children court, presiding officer of the children court, to take necessary steps for ensuring expeditious trial of the POCSO case number 48/2025. This bail application is accordingly disposed of.
Highly obliged.
Bail hearing item 25.
May I plead the lawsuit? My lord, application under 482 BNS. I'm on interim, my lords, who had order dated 9/5. Therefore, my lords, the case was listed thrice.
Is there?
Sorry, my lord, keep the note. Please.
What is the offense?
My lord, 85 BNS corresponding provision is 1498A IPC. Very minor offense, my lord.
He's an interim, my lord.
I'm on interim, I've appeared before the IO. Even before filing of this bail application, my lord, I had got a.
We'll
85
make it
BNS
absolute. 85. Heard. Why CD is not there?
Not mentioned, my lord, we have sent signal
4
Okay.
times.
Heard,
2017 and
heard Mr. S. Mitra, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that the petitioner was granted interim bail by this court on 9/5/2025. Stop. He also submits that in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. He also submits that on 4 occasions, the requisition for case diary was sent to the investigating officer. However, same has not been sent. Neither any reason has been shown for not sending the case diary. Considering the above facts, as well as the fact that the petitioner has, as well as the submissions made by learned counsel for the petitioner, that he has cooperated in the investigation, the interim bail granted to the petitioner by order dated 9/5/2025 is hereby made absolute, with condition number 1, Roman 1 and Roman 2 attached to the said order remaining intact. This anticipatory bail application is disposed of.
Much appreciated.
26. May I please, Your Lordship. My lord, the affair is to stay the previous bill application. There were 6 persons named in the affair, all of the family members. My lord, the informant's daughter and the affair name accused number 1. Please tell me.
Yes.
Informant's daughter and affair name accused number 1, they have secretly developed the love affair, man, without knowledge of the family member, my lord. And my lord, on 19/4/2025, at night, my lord, suddenly the boy, that is accused number 1 in the affair, and daughter of the informant reached at house, my lord. And my lord, they were very shocked, my lord. And immediately, my lord, they verified that the girl also not marriageable age, and boy also not marriageable age, because boy is only 20 years. And 21 is the marriageable age. And immediately family members inform over telephone the father of the girl, that is the informant, that your daughter has come in my residence. So whether you come to take back her or will hand over the police. Then informant replied that we are coming. You don't hand over the girl to the police.
Petitioners also Mr. A.K. Das, learned additional public prosecutor, as well as Mr. D.K. Bhattacharya, learned amicus curiae, appearing for the respondent number 2. This application under section 482 of BNSS has been filed by the petitioners, namely Shariful Islam, number 2, Safiur Rahman, number 3, Sabirun Nisa, who are apprehending their arrest in connection with Meresar PS case number 118/2025 under section 137 within bracket 2/127 within bracket 2/103 within bracket 1/3 within bracket 5 of BNS, read with section 4 of POCSO Act 2012. The gist of accusation in this case is that on 23/4/2025, the father of the victim girl has lodged an FIR naming 6 accused persons therein, including the present petitioners, inter alia alleging that the petitioners have kidnapped the minor daughter of the informant and it is also alleged that the accused persons named in the FIR had assaulted and killed the minor daughter of the informant on 21/4/2025 by showing it as a case of suicide. Learned counsel for the petitioners have submitted that the petitioners herein are in no way involved in the offense alleged in the FIR. He submits that the petitioner number 1 and 2 are the brothers of accused number 1, Musa Ali, with whom the victim had a relationship before her marriage. He also submits that the petitioner number 3 is the mother of the accused number 1, and they are innocent. He further submits that in the meanwhile, the main accused, the accused number 1, as well as 1, who else has been granted bail? Accused, as well as you said 2 persons were granted. Only 1 has been granted bail.
No, my lord, father also. Father petition in the FIR, serial number 4.
4. He submits that in the meanwhile, the main accused, Musa Ali, and his father, namely Abdul Salam, were arrested, and later on they were allowed to go on bail. The learned counsel for the petitioner submits that the petitioners are ready to cooperate in the investigation, hence they may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Mere Sir PS case number 18/2025 and has submitted that the death of the victim was due to hanging and a continuous ligature mark was found on the neck. He also submits that viscera report of the not received
Not continuous.
non-continuous ligature mark.
Viscera is also received, no poison has been found.
And viscera report has been also to the effect that no poison has been found. He also submits that the only material against the present petitioners in the case diary is that they were found standing near the dead body. On the other hand, learned amicus curiae has also, you are opposing,
Nothing to say because
has pointed out that in this case, the death of the victim, even if it is assumed to be suicide, happened in the house of the accused, house of the petitioners, where only the family members of the petitioners were present. And therefore, it appears to be suspicious. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. The investigation is going on. Truth would be revealed only after completion of the investigation. However, at this stage, as 2 of the co-accused are already released on bail and no such incriminating material as no such incriminating materials, comma, at this stage, comma, has been found against the above named petitioners. Hence, their prayer for anticipatory bail is allowed. Stop. The above named petitioners are directed to appear before the investigating officer of Meresar PS case number 18/2025 within
From Meresar to Saridwala.
Saridwar.
Saridwar PS case number, well,
84 Lordship.
Saridwar PS case number
84 later. Here it is 84. 84 stroke 25.
Saridwar 84, yes.
84/2025. Within bracket, the new case number after the FIR was transferred to Saridwar police station. Bracket close. Within a period of 10 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. Send back the case diary. This anticipatory bail application is accordingly disposed of.
Saridwar PS case number 84, public 2025. I am plus.
27.
May I please, your lordship? FIR is at page 13, lordship. Up to date CD was also called for, lordship.
Is it there?
On-
Statement of the victim is there. Lord.
On 19/6/2025, lordship. Up to date CD was called for, lordship.
I have found a 183 statement is there, Lordship, it is implicated. Implicate Lord.
What is your submission?
Lordship, lordship may kindly see the FIR, lordship. Page 13, lordship. Page 13, lordship, 13. May I read the relevant portion? Lordship?
Yes.
With due respect to state that on 30/4/2025 at around 6:30 PM, the aforesaid accused person came to my house and taking advantage of my absence in the house, he took my minor daughter, namely Miss X, 17 years, from my house to the accused house, eluding her and sexually assaulted the.
The section 482 of BNSS has been filed by the petitioner, namely Inamul Ali, alias Ainul Ali, who is apprehending his arrest in connection with Jagirod PS case number 100/2025 under section 137 within bracket 2/147, 142/64 within bracket 2 within bracket M of BNS, read with section 6 of POCSO Act 2008. The gist of accusation in this case is that on 2/5/2025, the mother of the victim girl had lodged an FIR that on 30/4/2024-25, the petitioner kidnapped the minor daughter of the informant and took her to his own house and subjected her to physical intercourse for whole night against her will. Thereafter, on 1/5/2025, the victim girl was handed over to the informant. learned counsel for the petitioner has submitted that the petitioner and the victim were in romantic relationship. And there was an agreement that after attaining the age of majority, the petitioner would marry the victim girl. And to that effect, an agreement was also executed between the mother of the victim girl and father of the petitioner.
Not father lordship, petitioner himself lordship.
Mother of the victim girl and the petitioner. The learned counsel for the petitioner submits that the petitioner is of a young age of 23 years and he is ready to marry the victim girl. However, if he is arrested, it would jeopardize the prospect of marrying victim girl. He also submits that the petitioner is ready to cooperate in the investigation and therefore prays for allowing the petitioner to go on anticipatory bail.
Other thing, lordship, if there is medical report, lordship, that also may consider whether what is the finding of the medical report.
Medical report is there. On the other hand, an additional public prosecutor has opposed the grant of bail. Sorry. Grant of bail to the petitioner on the ground that the victim girl has incriminated the petitioner in her statement made under Section 183 of BNSS. Positive.
No evidence of recent sexual intercourse and no any visible injury.
Completely is a false case, my lord. Just to trap me, lordship.
Incident is 34/2025. And it is
Medically examined on
3/5.
after a week, after 4 days. Okay.
So
Learned counsel for the informant has also vehemently opposed the grant of bail to the petitioner at this stage, as there are materials against the petitioner having committed forcible sexual intercourse with the daughter of the informant. Stop. I have considered the submissions made by the counsel for learned counsel for both sides and have gone through the records of case diary of. Show me the medical report. Gone through the case diary of Jagi Road PS case number 100/2025. On perusal of the Before the doctor, you said statement of the victim girl recorded under section 183 of BNSS. This court is of considered opinion that this is not a fit case where the benefit of a favorable order under section 482 of BNSS may be granted to the petitioner at this stage. The prayer for anticipatory bail is therefore rejected. Send back the case diary. This bail application is accordingly disposed.
Obliged, Lordship. Item 28. Please, Your Lordship. My lord, may kindly find the FIR at page 9, Lordship.
Case diary is not there.
Lordship, may kindly see the order dated 29/7. Last chance was given to them because today is the 5th occasion. CD is.
What is the offense?
Offense 108.
Why case diary is not there?
But on the same day, on 29th, the case came up, and on 30th, we have
Send the requisition.
Otherwise,
But it was,
calling CD. Lord.
yes, suicide.
otherwise, Lordship, there is no ingredients of section 108, Lordship.
How?
Lordship, there is no direct evidence. There are 4 accused persons, Lordship. Number 2, accused number 3 was arrested. 2 and 4 was enlarged on bail by this honorable court, anticipated bail. Now, number 1 is before your Lordship. And the FIR was lodged by the brother of the victim against the brother-in-law of the victim. The husband.
No, you are the main.
My name is there, number 1 is there, but whether I am involved, Lordship, that is to see, Lordship. I am placed in number 1 as accused person, but whether I am involved.
No,
There
that
is no allegation, direct allegation against me.
Yes,
and
it is there. You read.
Lordship,
It is there. Accused number 1 has been trying to do physical relationship with.
No, Lord. Actual fact is something different, Lordship.
No, at present accusation is there or not?
Accusation is there, but fact is something different, Lordship.
No, therefore case diary would be necessary.
But this is the 5th occasion, Lordship. There is no suicide note also there, Lordship. Suicide note also not there, implicating the present petitioner. And there is no any allegation against the petitioner that at any point of time she was subject to any harassment by the petitioner, Lordship. These are required, Lordship, because in case of suicide, there should be.
You read
direct.
the 3rd line.
Yes, Lordship. That is there, Lordship.
That is enough. If you try to.
But that is by the brother of the victim. And there is no suicide note, Lordship. It is not by not mentioned in the suicide note, Lordship. That is written by brother, just implicated. No suicide note is there. Had there been a suicide note implicating the petitioner,
There may be other evidence.
but they are
She
not
might
told
have told her brother, informant or some other witness the reason for committing suicide. Because this is a grave accusation that in absence of her husband, you tried to molest her.
But Lordship, I have stated, of course, this is my story, what I am instructed. Paragraph 4, Lordship, I have stated, Lordship.
This is anticipatory bail.
Yes, Lordship. She was having extramarital affair. I caught that, therefore this allegation.
When
Therefore,
can
she
you
committed
produce the
suicide.
case then?
14. Lord. Okay, Lordship on 18.
Till
Heard.
then, Lordship, I may be protected, Lordship, because this is the 5th occasion, Lordship.
No,
That may be
4th,
considered. No,
not
5th
Heard,
occasion.
Mr. M.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. this, who submits that the case diary is not available and prays for some more time for producing the case diary. He also submits that on the next day of date of passing of last order by this court, requisition for case diary was sent to the investigating officer of however, no reason has been shown by the investigating officer for not sending the case diary. Stop. Issue reminder for the case diary. The investigating officer may be intimated that in the event of failure to produce the case diary on the next date, he may have to appear personally before the court to explain the reasons for not sending the case diary when same is called for by this court. Considering the fact that this is for the fourth occasion that the prosecution side has failed to produce the case diary, the petitioner is directed to appear before the investigating officer within 7 days from the date of this order and cooperate in the investigation. And if he does so within this stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be granted interim bail by the arresting authority with following conditions, number 1 and number 2. Let the case diary be called for on after on 29th of August.
Deeply obliged. 29.
Yes.
May I please, your lordship? Lordship, FIR is at page number 13, lordship, 13. Lordship, may kindly peruse the FIR, lordship. Lordship, may kindly spare me from reading the FIR.
13.
13, 13.
Yes. Yes.
Lordship, may kindly.
Case diary is there? Yes, please.
Lordship, may kindly spare me from reading the FIR. Lordship, may kindly.
Okay. No, but you have to submit what is this.
I will submit.
I have read the FIR.
My submission is that, lordship, though the abhorrements are, lordship, volatile in nature, lordship, but the offences under which the case is tested, 192 is bailable, 300 is bailable, 196 and 299 are 3 years punishment. That is one part. And another part is, lordship, my story I have narrated at paragraph number 4.
What is your name?
Lordship, Shafiqul Islam. Whether there is anything against me in the case.
Shafiqul. No one has been named in the FIR.
No, lordship, no one has been named in there. And my story, lordship, is at paragraph number 4.
What is your story?
Story is that, lordship, the wife of the petitioner has been elected as a member of the Gaon Panchayat, and she campaigned against the newly elected Panchayat president, and therefore, lordship, the husband of the newly elected member came into the record.
Now, when no one has been named in the FIR, why are you apprehending
Yes,
arrest?
lordship, police visited my house.
Okay,
Other
yes.
things may be ascertained from the case.
Lordship, one of the witnesses has stated there's 2 persons, one present petitioner and another person's name, and third 3 persons are there. They conspire to do these things, lordship.
No, how that witness?
Witness has heard himself heard, lordship. It is there. If lordship want to look into it, lordship may.
Only that
only that. While conspiring lordship. Right.
what is your name? Safiqul.
Safiqul Islam.
At this stage, there are materials. You have been implicated by the witnesses. Do you have any other submission?
The custodial interrogation would be required, lordship, as because lordship, all the offences, lordship, 2 sections are bailable and 2 sections are non-bailable. Those are lordship, maximum punishment is there 3 years. And so far as section 13 is concerned, lordship, if we go by the contents of the FIR, that is not attracted, lordship. And lordship may impose any condition, lordship. I will abide by any condition. I will cooperate, lordship, even lordship, if need be, lordship. I will appear before the investigating agency, lordship, every week.
No. It is not a case of. Because it could have resulted in.
Lordship, that is admitted, lordship. That is why, lordship, I have not read all the averments, lordship. These are volatile in nature, lordship.
Very volatile.
Very volatile. That is admitted, lordship.
Okay. Heard. Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Safiqul Islam, Ramesh, live streaming to Safiqul Islam, inter alia.
It is not available.
But herein there is no any interim, your lordship. And we
What
are
is-
also not the affair name accused, your lordship.
What is the offense?
Offense herein, one person had taken passbook, ATM card and SIM card of the wife of the informant, your lordship. And thereafter, the bank manager informed the informant that some amount was credited from unknown source.
Why are you apprehending?
We are apprehending because of that. Our brothers have already been arrested, but the police have already visited our house.
Case diary would be required. Nature of.
If your lordship will go by.
Where do you stay? Murigaon.
No, Disney. Sirang.
Heard Mr. A.M. Khan, learned counsel for the petitioners. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. When? Let this case be
In
listed
the
on.
meantime, your lordship, if your lordship will find any adverse remarks against the petitioner, then your lordship will definitely reject. But in the
No.
meantime, I'm saying,
No protection. No.
then little bit short.
18.
19 and
18 is little bit
Before-
short.
Before 15 year lordship.
No, lordship. Do not come again.
CD may not come. Let it be on 19. 19.
Order item 31.
Please, Lordship. Lordship, I am appearing on behalf of my senior Mr. D.K. Kothari. Lordship, on the last occasion, the matter was taken before the Lavazima court, dated 22/7/2025. On the order, it is mentioned that the appellant took issued notice upon the respondent, but the same was returned as without any AD card and unserved notice was received. Lordship, as per the instructions received by the appellant wants to seeks to withdraw this instant appeal.
Appellant has been punished. This appeal is against which order?
Against the acquittal.
Or against acquittal?
Yes.
Okay. Heard Mr. A. Chetri, learned counsel appearing on behalf of Mr. D.K. Kothari, learned counsel for the appellant. He submits that the appellant appellant intends to withdraw this. No, he prays for allowing the appellant to withdraw the instant criminal appeal. He has preferred against acquittal of the respondents. Stop. Considering the submissions made by learned counsel for the appellants, the prayer is allowed. This appeal against his acquittal is dismissed on withdrawal.
Perhaps we require some time. There are two appeals, connected appeal. Item number 32 and 33. I am appearing in connection with item number 33.
I am appearing on 32.
Whether Lordship will take up the matter, because it requires some time. 9 persons were examined. An allegation is otherwise serious. His genital organ was severed. Then he was thrown out in the river Brahmaputra. And this way, that way, he survived. Ultimately, my lord, trial was
Sharma, you are
concluded.
ready?
So in fact, the counsel for the item number 32 had asked me that we will be seeking an adjournment. So, no,
Okay. Who is appearing for 32? You are seeking an adjournment?
Yes.
Why? Time. Stop.
Another was ready, my lord.
Okay. No, if it is not possible to
My lord.
complete within
Yes.
45 minutes,
My lord. It may not be
will
possible.
not start.
My lord. The Lordship may kindly subject to convenience, my lord.
Yes.
We have already, my lord, discussed the matter. Let the matter be listed on 12th of August. There's an old pending case, my lord.
No, let it be decided by the registry.
My lord.
We'll give a specific time,
My
not date.
My lord, date may kindly be fixed. Otherwise, my lord, I may be in troubles, my lord, because I will have to go to an outlying bench.
Since it is a 2012 matter, also it will be listed by the.
Yes.
Lordship may also fix the matter. No.
No, I don't know the board. Heard Mr. A.K. Purkasta. No. What is your name?
Islam on behalf of APOC.
Heard Mr. A.
Islam on behalf of APOC.
F. Heard Mr. A. Islam submitting on behalf of F. Hawk in criminal appeal number 58/2012. Also heard Mr. A.K. Purkasta, learned counsel for the appellant in criminal appeal number 131/2012, as well as Mr. B. Sharma, learned additional public prosecutor. It is submitted at bar that this appeal would require some time for hearing, and due to paucity of time, it may not be possible to complete the hearing today. Stop. Considering the submissions made by learned counsel for both sides, this appeal is adjourned for today. Let this matter be listed. In which week you want?
I prefer my lord 12th.
No, you cannot.
That's why my lord, I'm
choose.
saying subject to convenience. That is moving to me.
In the 4th week of August, in the 3rd week of August, on a date to be fixed by registry. Let registry fix date. We are
My lord.
in the 3rd week of August on a date to be fixed by registry.
My lord. Third week will start from 18.
Item 45. 4th week.
4th week I will be out of station. My lord.
4th week will be starting from 18 Lordship.
4th week.
Yes, first week is Lordship.
Okay. In the 4th week of August, on a date to be fixed by registry.
May I please? It's a criminal appeal. So the time will permit, I will take 30 minutes.
30.
I'll try to. And if possible, Lordship, we may fix it tomorrow, Lordship, if possible.
Oh. Tomorrow it is not possible. Next week.
This is appeal of 2013, Lordship.
Yes, Mr. Sharma.
Sir, ready then?
Let it be on the same week, Lordship, 4th week, probably on hearing day.
How many witnesses are there?
9. Lordship 10, including the IO.
So if you are seeking 30 minutes, that means you will take at least minimum 1 hour.
No, Lordship, I will try to be within 30 minutes. I will not go beyond 30 minutes.
We also could not go through it.
4th week.
Paper book is there, Lordship.
4th week.
What is the paper book?
Heard Mr. S.K. Poddar, learned counsel for the appellant, also heard Mr. K. and Mr. B. Sharma, learned additional public prosecutor. This matter could not be taken up for hearing due to paucity of time. Hence, start. No, we will
Otherwise,
fix
will
it.
come, Lordship, again. It will
No,
again-
we'll fix it. Week. Let this case be listed in the 4th week of August.
Can it be on the 1st week of September, Lordship?
In the
I
first week of September, on a date to be fixed by registry.
Oblige.
Item 46.
Maintenance been on a BBG at my lord. Whether Lordship, we could take up the-
What is the issue?
There is the order of maintenance, my lord. Filed by, granted to the opposite party, my lord. At the rate of 7,000 under the domestic violence act 2000.
Both of you are ready.
Ready. Otherwise,
Yeah, around date may fix it tomorrow. I have another matter in the court. So both are next cycle.
You are enjoying interim.
No interview.
But it's a 2015 matters. The amount.
No,
is
but
very-
that time will also permit, if I have to go to the evidence also, I will not see.
If it is not possible, we'll take some other method.
Convenient date.
Okay. Due to paucity of time, this matter could not be taken up for hearing today. List this matter in the 4th week of August on a date to be fixed by registry.
Right.
47.
May it be the lordship. My lord, 138 case, page 24 is the conviction, para 10. 170 was the check. And
You are ready?
my lord, we have paid 2 lakhs and they don't want to go any further. So we have paid the amount.
Oh, yes, yes. Oh,
Page 24, para 10. Along with the compensation, I have paid the amount. Check was of 170.
no, they may file an application that matter has been compromised.
Because both are neighbors. What I understand, both are neighbors. So they don't want to.
No,
proceed.
if it is to be disposed of on composition, compromise,
Then the application has to.
then
be filed.
application has to be there. Both of you file,
Joint
may
application.
file a joint application.
Joint application.
Heard, Mr. P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. A. Malik, appearing on behalf of F. A. Laskar. It is submitted at bar that this matter has been amicably settled between the parties, and therefore a prayer is made to allow both the parties to file a joint application for compromising, for disposing of this case on composition, on compromise. Stop. The prayer is allowed. Let this matter be listed next week. When?
Any day after. First week of September. First week of September.
In the first week of September, on a date to be fixed by registry.
God bless you.
Item 38.
Yes.
Chip, I'm on behalf of my senior A. Somwa. He had to leave the premises today due to personal emergency.
Isonwal is for the
Appellate.
for the petitioner or for the appellant? A. Chamua. Okay. So you are seeking an adjournment.
Yes.
What is your submission?
Chip,
You are conceding.
I asked whether he the matter. He told that yes, we will be doing it today. So I'm prepared with the matter. But
Now what is your submission?
he had to take the personal difficulty.
Okay, heard Miss, what is your name? Heard Miss S. Deka submitting on behalf of Mr. A. Samoa, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty of the conducting counsel. Also, Dr. P. Agarwal, learned legal aid counsel appearing for respondent number 2, as well as Mr. K.K. Das, learned additional public prosecutor, who do not object to the prayer made by the learned counsel for the appellant. Hence, this appeal is adjourned for the day. Hence, this appeal is adjourned. Stop. Let this matter be listed. When do you want?
First week of September.
Let this matter be listed in the first week of September on a date to be fixed by registry.
Item 49.
May I please, Lordship? Lordship, can you fix for any other date for hearing, Lordship?
Why? Time is.
This is very narrow issue, my lord. Enhancement part, that's it, my lord. There was an order passed by the learned trial court under the DBA, whereby as per section 22, my compensation part, I was awarded a compensation of 1 lakh, apart from other heads, my lord. Against that order, I filed an appeal, statutory appeal under section 29, whereby the compensation was enhanced by the learned appellate court from 1 lakh to 2,50,000. Against that enhancement, they have come up before this. That is the
DB Act.
Yes, madam.
He is your husband.
Yes, ma'am. He was my.
There is no divorce.
my lord.
She divorced to police already. And she also received her Maharana amount and 1 lakh rupees, 1 lakh which is given by the learned judicial magistrate first class lordship. It is also paid by the petitioner, lordship, appellant petitioner here. Lordship.
Now 1,50,000 is.
And again,
Due.
again 1,50,000.
What do you
is
do?
lordship. Lordship, it's burden, it's still a burden of upon the petitioner, lordship, as he is paying the monthly maintenance of 15,000 per month. Lordship, 9,000 for his wife and 6,000 for his child.
Now what do you do?
Today, lordship, maybe for hearing, lordship, may first, for hearing, lordship,
What the petitioner do for earning?
oh, he is a CRPF employee, lordship.
Then you can pay 1,50,000.
Yes. So there is some burden of him, lordship.
But
As he has
your
already-
daughter is
as-
with your
Daughter is also along with the
your former wife.
her mother, along with her wife.
So why don't you pay?
I have already paid 1 lakh rupees, 1 lakh also. Already paid rupees 1 lakh earlier. I have annexed the water sheet also. Lordship.
No, that is not the issue
And
before. the-
along with lordship, along with monthly.
On what
maintenance-
ground you have preferred in this appeal?
I have not gone through the lordship due to some personal difficulties. So lordship fixed the matter after 1 year. Lordship. I go to.
Your NC. Okay, let us. You are not ready or what?
I have not gone through the. Lordship.
Okay, okay. Heard Mr. N.H. Laskar, learned counsel for the petitioner. Also heard Mr. A. K. Mohammed, learned counsel appearing for respondent number 2 and 3. State is also party. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that he has not gone through the brief today and needs some time to prepare before he makes his submissions in this case, and therefore he seeks a short adjournment. Considering the submissions made by learned counsel,
My objection. I have objected.
the learned counsel for the respondent number 2 and 3 have objected to the prayer of adjournment. However, considering the ground shown by the petitioner for seeking adjournment, the prayer is allowed. Let this case be listed. When do you want? This is not a long matter.
Yes,
We can fix it in a specific, on a specific date.
26 or 27, lordship.
Let this matter be listed on
26.
26th of August.
I'm deeply.
Item 40.
Matlab,
May I please, lordship? Lordship, this matter, lordship, there is an IA for lordship suspension of sentence also, lordship. I think it should be listed in orders column. Anyway, lordship listed in the hearing because the
no, but
paper
if it is listed in hearing column,
book is also not prepared, I think.
paper book not prepared.
Not prepared, lordship. And lordship, I am at this stage paying for the IA lordship because she has been sentenced for a short-term period of 5 years, lordship. And almost 2 years.
No, we will
My-
direct the preparation of paper book. And if you are pressing for interior, then it will have to come in
Orders
orders.
column. Then lordship may
Or
fix it for orders because she has been sentenced for short term and.
paper book may take time.
Yes, lordship, that's why lordship. Section 21B আছে 5 বছর দিছে 2 বছর হবে মানে 1 year 11 months.
Heard Mr.
J. Abbas.
J. Abbas, learned counsel for the petitioner. Also heard Mr. V. Sharma, learned additional public prosecutor. It appears that in this case, no paper book has been prepared. However, the necessity of same has been felt by both the councils as well as this court. Therefore, registry is directed to prepare paper book of the trial court records. Stop. And list this case for hearing.
Lordship, may kindly fix for orders column because the petition is also pending.
Stop.
In the meantime,
Stop. No, list this case for hearing continued. Stop. It also appears that one interlocutory application, that is IA number 255/2025, has been filed by the appellant seeking suspension of sentence, suspension of the execution of sentence during the pendency of the present appeal. Hence, let this case be listed along with the aforesaid IA in the orders column on
Lordship, 3 Lordship.
3rd September.
Or if before that, if
No fixed date. In the 4th week of August, on a date to be fixed by registry.
obliged.
Finish.